Good morning. I'm Commissioner Procco. This is the 8 a.m. initial appearance calendar for April 24, 2025. The court's orders for the taking of DNA and fingerprints that were given on the first calendar of this month shall apply to all matters on this calendar as well. All right, when you hear your name, please step up to the podium that's in the center of the courtroom in here. At the end of your hearing today, you are going to be receiving some paperwork that will cover everything we go over in here, which does include your next court dates as well as all of your release conditions. For those of you who will be out of custody prior to your next court date, I do recommend contacting the court in advance of that date so you can verify your hearing details. You can also check to see if there are other ways of appearing, since some of the courts are still allowing for virtual appearances for some hearing types. Please keep in mind you have the right to remain silent. Everything you say in here is being recorded, both audio and video, and could be used in a future court proceeding. We're going to begin today with Joseph Riccardi. Mr. Castellanos, are you able to hear me? Hold on one moment.
Yes, Your Honor.
Okay, looks like I don't have any interpreter matters marked here, but would you be willing to just double check to make sure we didn't miss anyone?
Yes, of course. ¿Se encuentra alguien en la sala que requiera asistencia de un intérprete de la lengua español? Si puede levantar la mano el que necesite asistencia de un intérprete.
No hands? All right, looks like we don't have anyone. Thanks so much for checking in with us.
My pleasure, Your Honor. Have a nice day.
Thank you. All right, so Mr. Riccardi, go ahead and step in. After that's going to be Joseph Thomas. All right, sir, your full name and date of birth.
Joseph Michael Riccardi, January 27th, 89.
All right, thank you, sir. So you've got 4 separate cases here on the calendar today. So I believe 2 of these are going to be for warrants issued for direct complaints filed. Why don't I go ahead and start with those matters? So in each of those cases, a direct complaint has been filed with the court. The first one is for 1 count of possession of narcotic drugs, class 4 felony, 1 count of possession of drug paraphernalia, class 6 felony. That one has a offense date of July 13 of 2023. Your next direct complaint involves 1 count of possession of narcotic drugs, 1 count of possession of dangerous drugs, both class 4 felonies, 1 count of possession of drug paraphernalia, class 6 felony, and 2 counts of DUI. Those are class 1 misdemeanors. That one has an offense date of April 28 of 2024. So in each of those matters, the public defender has been appointed. Your status conference is set on April 30 at 8:30 a.m. with that preliminary hearing May 2nd at 8:30. Those are going to be at the Superior Court in downtown Phoenix. The bond in each of those warrants has been affirmed. So the first one was a $50 bond. The next one is a $1,500 bond. Those are secured appearance bonds. Your next case that I have here is going to be your matter that's already open. This is for a bench warrant that was issued for failure to appear. Looks like right about a year ago. So in that matter, you now have a status conference April 30 at 8:30, and in that case, there's a $1,000 secured appearance bond. Looks like you're still pending sentencing in that case. Now, your 4th and final matter here is the new charge that just came in. So this will be for a new charge submitted in Superior Court. That's 1 count of possession of drug paraphernalia, which is a class 6 felony. So in that matter as well, the public defender is appointed. They're going to have the same court dates there, with that status conference April 30 and preliminary hearing May 2nd. But in this matter, you also have an evidentiary hearing set on May 1st at 1:30 p.m. And the reason we set that is because you do have a no bond hold in this matter. If you commit a new felony offense while being on felony release in another case in Arizona, you are required to be held without bond at your initial appearance. So that's your situation here today. So that's why we set that evidentiary hearing up so the court can review that. Do you have any questions regarding any of these 4 matters here? All right, if you want to go and step over, looks like your paperwork's ready to go. You can go ahead and have a seat at this time. We've got Joseph Thomas. After that, it'll be DeAndre Brown. Hi, Mr. Thomas. Want to state your full name and date of birth?
Joseph Jerome Thomas, 21292.
All right, thank you. You were here for 5 separate cases here today. So in your matter, I'll do the same thing. I'll start with the direct complaints that you have here. You've got 2 separate direct complaints that have been filed. And in each of these cases, well, let me start with the first one. The first one, which is the 2025 matter ending in 117, the single count on that complaint is shoplifting, a class 4 felony with an offense date of February 11 of 2025. Your next direct complaint, which is another 2025 case, this one's ending in 097, involves 4 counts of shoplifting, all class 4 felonies. The dates of offense there are May 2nd, July 14, July 17, and November 5th of 2024. So in both of those matters, the public defender's been appointed. You have a status conference set on April 30 with a preliminary hearing May 2nd. Those are both at 8:30 a.m. And in each of those matters, the bond and the warrants have been affirmed. Each of those has a $5,000 secured appearance bond. In all of these, you are going to have orders that you are not to return to the scene of the offense or have any contact with any complainant or witness. You are also going to be ordered to contact probation within 72 hours since you are still on supervised probation. So your next two matters here are going to be your probation cases. They are here because a probation or a warrant was issued for a failure to appear in each of those matters. So in both of those cases, you now have a non-witness violation hearing May 1st at 8:30, and in each of those, the bond and the warrant's been affirmed. Those each have a $1,000 secured appearance bond. Your fifth and final matter here is going to be for the new charges that were just submitted. These will be out of the Maricopa County Superior Court. There are a total of 16 counts of organized retail theft, Class 4 felony, 6 counts of shoplift as a Class 4 felony, and 1 count of possession of narcotic drugs. That's also a Class 4 felony. I believe there are about 16 separate dates of offense here. Those range between January 22nd of 2025 and April 23rd of 2025. The public defender's office has been appointed. You have a status conference April 30 with a preliminary hearing May 2nd, both at 8:30. Those will be at the Superior Court in downtown Phoenix. In addition to obviously being a flight risk since you don't appear for your court dates, as well as having this many counts now of probation, it appears as though if you were convicted, you are certainly looking at some time in the Department of Corrections. You do have a bond in this matter that's a $50,000 cash-only appearance bond. You'll receive paperwork for each of these matters, but you're going to get that here in a moment. Do you have any questions, though, regarding any of them?
No, ma'am.
All right, sir, if you want to go and step over, go and pick up that paperwork over there. We've got DeAndre Brown, Henry Wright. We'll be up after that. All right, sir, your full name and date of birth.
DeAndre Brown, May 4th, 2005.
All right, thank you, sir. So you're here for a grand jury warrant that was issued, and this is going to be for an indictment file alleging 1 count of burglary in the 3rd degree. That's a Class 4 felony. It has an offense date of February 20 of 2025. So in this matter, the public defender's office has been appointed. You have an arraignment hearing set on May 1st at 8:30 a.m. The bond in that warrant's been affirmed. That's one's a $20,000 cash-only appearance bond. So this would be in addition to any other bond you have in your other open matters that you're already in custody for at this time. You do have the same release conditions here that you do have in your other burglary case, that you're not to return to the scene of the offense, not have any contact with any alleged victim, complainant, or witness. Do you have any questions regarding that? All right, sir, if you want to go and step over, you can go and pick up that paperwork. All right, we have Henry Wright, and then Gail Garcia. We'll be up after that. All right, sir, your full name and date of birth.
Henry Wright, 7/30/1992.
All right, thank you, sir. You are here for a new case out of the Maricopa County Superior Court. The 2 counts that probable cause was found on here today is 1 count of possession of dangerous drugs for sale, which is a Class 2 felony, and 1 count of possession of dangerous drugs. That's a Class 4 felony. There was an additional count submitted for possession of narcotic drugs. I didn't find probable cause on just that 1 count. Doesn't necessarily mean it's going away, but they did not provide me with enough information today. So the public defender has been appointed to represent you in this matter. Your court dates you have at this time are going to be a status conference set on April 30 with that preliminary hearing May 2nd. Those are both going to be at 8:30 a.m. at the downtown Phoenix Superior Court. Based on a review of your history, which does include quite a few prior convictions, as well as the fact it appears as though you were just recently released from the Department of Corrections and are still currently on parole, you do have a bond that's a $15,000 secured appearance bond. If you are in fact on parole, I would not be surprised if you see a parole hold coming. It doesn't appear as though one was showing up on my end at least, but you might want to check on that before you post any bond in this matter. Any questions regarding that?
No.
All right, if you want to go and step over, you can go ahead and pick up that paperwork over there. All right, so we've got Mr. Garcia. Russell Baker will be up after that. And sir, your full name and date of birth.
It's Yayo Garcia, and June 28, 2005.
All right, thank you, sir. You've got 3 separate cases here today. Looks like all 3 of these are here for bench warrants issued for failures to appear in your 2 probation matters and your open felony case. So in this matter, the warrants, or the bond and the warrants, have all been affirmed. So the first one is a $10,000 secured appearance bond. The probation matters each have $250 secured appearance bond, so it's $10,500 for all 3. So in those matters, you do have a status conference now set on May 5th at 8:30 a.m. That'll be in front of your assigned judge in this matter. So that applies to all 3 cases. Do you have any questions regarding that?
Yes, Your Honor. For this case, I already had posted a bond of $6,000, and I wanted to see what happened like with that money, or like as.
All right. So what happens in that is they usually set a forfeiture hearing. I don't know if one's been set in your case or not. It wouldn't have happened yet because I think this is a very recent warrant. Okay. So that is an issue to talk with your attorney about. Okay. Because when you post a bond and then fail to appear at a subsequent hearing, that bond amount could be subject to forfeiture. All right. So that's an issue you want to discuss with your attorney, though. Okay.
Okay. And may I ask another question? It's because they did say, like, it was last time that there was a forfeiture hearing, but I asked my attorney about it, and like he said that it looked like there was nothing, like there was no forfeiture yet, because like they gave me 2 court dates and I wasn't supposed to go to the first one, only the second one, and I missed the first one.
All right, you're going to receive notice of any hearing that gets set in your matter. Because this was so recent, I can't even tell if the court set a hearing for you in as far as the forfeiture goes, because it's not even showing up on my end yet. So again, that's going to be something that would show up on your docket, though. When you look at your court case online even, it'll show all your court dates, and those would be among the court dates that it would show. But yeah, you'll receive notice if they set a forfeiture hearing.
Okay.
Okay.
And I would ask, who would I ask, my attorney, or? Like,
yeah, talk to your attorney about it.
Attorney?
They'll be able to let you know. They'll know what happened at your last hearing, because there'll be a minute entry that says whether or not they've done a forfeiture hearing.
Oh.
And it won't have taken place yet. Okay, this was way too recent, so nothing's happened yet.
Okay. But this was for another case like this.
Oh, this was for another case entirely, not the 3 that you're here on right now?
No, it was the same thing, but I had a failure to appear for those ones. But like they told me I was supposed to show up to the first one, only the second one, and they wanted to do the bond forfeiture, but like I don't know.
No, I wish I could tell you I knew what you were talking about and be able to answer that question better. But yeah, the best thing I can tell you is talk to your attorney. Pay attention to your court dates. Make sure you keep your address current with the court, because that's how they send you all the notices. So if they set a hearing for any purpose at all, including a forfeiture hearing, they send that notice to you.
Okay.
Okay?
Yeah.
All right. If you want to go ahead and step over, you can go ahead and pick up that paperwork that's over there. All right, so we have Russell Baker and then Monty Kitchens will be up next.
Russell Baker.
Full name and date of birth.
Pardon?
Your full name and your date of birth.
Russell Baker, 10/8/59.
All right, thank you, sir. So you're here for a grand jury warrant that was issued, and this is for an indictment that's been filed. It alleges 1 count of possession of a weapon by a prohibited person, which is a Class 4 felony, 1 count of possession of dangerous drugs, and 1 count of possession of narcotic drugs. Those are both Class 4 felonies, and 1 count of possession of drug paraphernalia. That's a Class 6 felony. All of those have a date of offense of April 20 of 2024. So in this matter, the Public Defender's Office has been appointed. You have an arraignment hearing set on May 1st at 8:30. That'll be at the Superior Court in downtown Phoenix. The bond in that warrant's been affirmed. This is a $5,000 secured appearance bond. So you are able to work with a bail bonding company in order to post that amount. The only additional terms you have here that you are not to have any contact with any complainant, witness, or co-defendant, if there is one. I'm not aware of one. And you're not to possess any weapons given your history. Do you have any questions regarding that?
No,
All right,
ma'am.
sir. If you want to step over, you can go and have a seat at this time. All right, and Monty Kitchens and Aaron Cooper up after that. All right, so your full name and date of birth.
It's Monty Kitchens, 03191990.
All right, thank you, sir. So you are here for a warrant issued out of probation. This is for what is really a supplemental petition to revoke. So it's an additional petition to revoke filed in your probation matter. It's for a violation of terms 1, 3, 5, 7, and 15 of your probation terms. So in that matter, the revocation arraignment hearing is now set on May 1st at 8:30. That's going to be at the Superior Court in downtown Phoenix.
Yes,
I'm not addressing counsel because you already had an attorney appointed in this matter.
Yes, Your Honor.
So in this case, the bond in that warrant's been affirmed. This one's a $1,000 secured appearance bond.
Yes, Your Honor.
You're going to have the same terms here. If you do postpone and do get released, you do need to contact probation within 72 hours
Yes,
and
Your Honor.
otherwise comply with those terms.
And this is the same charge that was already for the 25th, correct? The same.
I don't know what you mean for the 25th. What's the 25th?
On the 25th, I believe I had a court date for the violation of probation. I don't know if
This is a new petition.
This is a new petition, so there's two
this is
now.
a very recently filed petition. Like I said, it's considered a supplemental petition to revoke.
Supplemental.
It's a second petition filed while one is already pending.
One is okay.
Yeah, so this is a new petition.
So do I contact probation when I get back to, I'm sorry, Your Honor.
If you get released from custody, you do need to contact probation. That's required as part of your probation terms. Otherwise, if you don't get released, if you remain in custody, you'll get brought to that next revocation arraignment hearing. You can speak to your attorney at that point because they're probably going to try and join this one up with your existing case that you have. All right. If you have an earlier case or if you have an earlier court date in this matter, it's likely you'll go in for that court date too, whether you're in custody or out, because it'll show you're in for this CR number. You can talk to him about it at that point too.
Okay, Your Honor. So I just contact the same attorney and then...
Yeah, it should be the same attorney.
Okay.
Yeah, let him know you've got a supplemental petition.
Supplemental petition letter. Okay. Interesting. Okay. Thank you. All right.
All right. If you want to go and step over, you can go and pick up that paperwork that's over there.
Thank you, Your Honor.
All right. After Mr. Cooper, we've got Bradley Brennan. Mr. Cooper, if you can state your full name and date of birth.
Oh, I'm Bradley Brennan.
You are Bradley Brennan.
Bradley.
No, he's already in here, so. All right. State your full name and date of birth.
Bradley Michael Brennan, 10-11-88.
All right, thank you. So you are here for two separate matters here today. So each of your cases are going to be for probation violation warrants that were issued about a month ago. And those are alleging a violation of terms 3 and 5 of your probation term. So the public defender has been appointed for you. You have a revocation arraignment hearing set on May 1st at 8:30. That'll be at the Superior Court in downtown Phoenix. In each of these matters, the bond and the warrant's been affirmed. Those each have a $500 secured appearance bond, so it's $1,000 total for both. If you post bond and are released from custody, you're still on supervised probation, so you do still need to contact probation within 72 hours of your release from any facility and otherwise comply with the remaining terms, okay? Do you have any questions regarding that? All right, sir, if you want to go ahead and step over. All right, do we have Mr. Cooper here? Yep. And then after that, we're going to have Cecilia Munoz. All right, Mr. Cooper, go and state your full name and date of birth.
Aaron Travis Cooper, 10/27/1985.
All right, thank you, sir. So you've got three separate cases here today. I'm going to start with the new matter that just came in. This is going to be for a new case out of the Maricopa County Superior Court. The charges that were submitted there are 1 count of possession of dangerous drugs, that's a class 4 felony, 1 count of possession of drug paraphernalia, class 6 felony, 1 count of criminal trespass in the 3rd degree, which is a class 3 misdemeanor. Those are the 3 counts that probable cause was found on here today. There is an additional account that has been submitted. That's for 1 count of possession of narcotic drugs. No probable cause was found on just that 1 count, which doesn't necessarily mean it's going away, but I was not given enough information. So the public defender's office has been appointed. We have a status conference set on April 30 with that preliminary hearing May 2nd, both at 8:30. Those will take place at the Superior Court located in downtown Phoenix. In this matter, because you are going to get bonds in your 2 other cases here, which are your probation matters, you do have $50 cash-only appearance bond in this case only. So if you do post bond and are released, since you are still on supervised probation, you do still need to abide by all terms of probation, which does include contacting them within 72 hours of your release. Your next 2 cases here are those probation matters. The reason they're here today is because a Term 1 violation has now been issued. So in each of those, you have a revocation arraignment hearing on May 1st at 8:30, still at the downtown Phoenix Superior Court. The bond in each of those matters is $250. So it's $500 secured appearance bond for the probation cases. Okay, so it's $550 total for all 3 matters. You'll get individual paperwork for these cases. I'll have all that information in it as well, but do you have any questions regarding it?
Sure.
All right, if you want to go and step over, you can go ahead and have a seat. All right, so we've got Mr. Brennan, so now we're to Cecilia Munoz, and then Xavier Gonzalez will be up after that. All right, sir, your full name and date of birth.
Cecilia Munoz, April 25th, 1983.
All right, thank you, sir. So you are here for 2 separate cases here today. So this is going to be, I'll start with your new case. That'll be out of the Maricopa County Superior Court. The charges are 1 count of possession of narcotic drugs. That's a Class 4 felony. 1 count of possession of drug paraphernalia, Class 6 felony. So in this matter, the Public Defender's Office has been appointed. You do have a status conference set April 30 with a preliminary hearing May 2nd, both at 8:30. This will be at the Superior Court in downtown Phoenix. So in this matter, because you are going to have a bond on your probation matter, which is also here today, we're about to review it. You do have a $50 bond in this case. So this is a $50 cash-only appearance bond. Your probation case is here today for a Term 1 violation. So in that probation matter, you also have the public defender appointed and a revocation arraignment hearing set on May 1st at 8:30. That again will be at the Superior Court in downtown Phoenix. Your bond in that matter is a $500 secured appearance bond. So it's $550 total for both cases. Now, if you do post bond and are released from custody, you are still on supervised probation. You do still need to abide by all terms, including contacting probation within 72 hours. Do you have any questions regarding either of those two matters that I've just gone over? All right, sir, if you want to go and step over and pick up that paperwork that's just over there. Thank you. All right, so we have Mr. Gonzalez, and then Andres Garcia will be up after that. All right, sir, your full name and date of birth?
Salvador Gonzalez, 102493.
All right, thank you, sir. So you've got 2 separate cases here. Looks like you were just here last night, I know on another matter, but you had some outstanding warrants in your probation cases, which is why we had to have you come in again, because I have to see you on those. So for both of those probation matters, you do have a petition to revoke filed that alleges a violation of terms 3 and 5 of your probation terms. The public defender has been appointed there. And you have a revocation arraignment hearing May 1st at 8:30 at the Superior Court in downtown Phoenix. The bond in each of those warrants has been affirmed. So they each have a $200 secured appearance bond for $400 total. So if you do post bond and are released from custody, you do need to contact probation within 72 hours and otherwise comply with your term.
Okay.
All right, any questions?
No.
Thank you, sir. All right, so we've got Andres Garcia, and then Eddie Palms will be up next. All right, sir, your full name and date of birth?
Andres Garcia, 9/23/1995.
All right, thank you, sir. You are here for a warrant that was issued out of the South Mountain Justice Court. That's in their case number JC 2021-143423. In that matter, an arraignment hearing has been set April 29 at 8:30. That'll be at the South Mountain Justice Court. This is now the 3rd warrant issued in this matter, so the bond there has been affirmed. This one is a $500 secured appearance bond. Since I did set a bond in this matter, I did also appoint the Public Defender's Office for that issue as required by Rule 6.1. So you'll get that information here in a moment, but do you have any questions regarding any of it?
No, just pay bond and I'll be able to get released, man?
Yeah, if you pay the bond in this matter, you would be eligible for release, assuming you have no other holds. I'm not aware of any, but they'll let you know if you do.
All right, sounds
Okay.
good. All right, thank you.
All right,
Appreciate
thank you.
it. Yep.
All right, so we have Eddie Palms, and then Kyle Lustig will be up next. All right, sir, your full name and date of birth?
Eddie Pons, 090999.
All right, thank you, sir. So you're here for a bench warrant that was issued for failure to appear in CR 2022-000319. So in that matter, you now have a status conference set April 30 at 8:30. That'll be at the Superior Court in downtown Phoenix. The bond in your warrant has been affirmed. This one is a $100 secured appearance bond. So that is the amount you'd have to post to be released in this matter. Do you have any questions regarding that? All right, sir, if you want to go and step over, you can go ahead and pick up that paperwork that's over there. We have Kyle Lustig, and then Jesse Vega will be up next. Okay, sir, your full name and date of birth?
Kyle Richard Lustig, March 28, 1985.
Thank you, sir. So you are here for a warrant that was issued for a direct complaint that's been filed. It's for 1 count of possession of narcotic drugs, Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony. It has an offense date of September 24 of 2024. So in this matter, the Public Defender's Office has been appointed. A status conference is set April 30 with a preliminary hearing May 2nd, both at 8:30. Those will be at the Superior Court in downtown Phoenix. Now, in this case, I do show you already have that DOC hold that's keeping you in custody either way. So I did go ahead and just put a placeholder bond here. You do have a $50 cash-only appearance bond, so they know you're in custody in this matter as well, okay? Do you have any questions regarding that?
No, thank you.
All right, thank you. All right, so we have Jesse Vega, and then Jasmine Cibrian will be up next. All right, so your full name and date of birth?
Jesse Vega, July 17, 1995.
All right, so you're here for a probation violation warrant that was issued. This is for a petition to revoke filed alleging a violation of terms 1, 2, 3, 6, 12, and 15 of your probation terms. The public defender's office has been appointed to represent you. You do have a revocation arraignment hearing May 1st at 8:30, and that'll be at the Superior Court in downtown Phoenix. I do show that you did go into the probation office, which is when you were arrested in this matter. I also show that you don't have any other prior reinstatements, although I think this is the second petition to revoke that's been filed in this matter. So because you don't have any of those and you did go into probation, I am going to release you to appear at that next court date on your own. You are being released on your own recognizance, but you are still subject to the supervision of your probation officer. You do need to continue to comply with probation, or a supplemental petition to revoke could be filed, okay? So you do need to also contact probation within 72 hours. I know you just saw them right before you came in here, but go ahead and do that again since that's required.
Okay, thank you.
All right, any other questions? All right, if you want to go ahead and step over, you can go ahead and pick up that paperwork there. All right, so we have Jasmine, Cibrian, and then Cassius Porter will be up after that. All right, ma'am, your full name and date of birth.
Jasmine Martinez Cibrian, June 9, 1990.
All right, thank you. So you are here for a new case out of the El Mirage Municipal Court. This is for 1 count of criminal damage, 1 count of disorderly conduct. Those are both Class 1 misdemeanors. So in this matter, it is considered domestic violence offense in nature, so you are entitled to court-appointed counsel, but that will be handled by the El Mirage Municipal Court. So they'll address that at your arraignment hearing. That would take place on May 13 at 8 a.m., and the address for the court will be included in your paperwork. So in this matter, based on a review of your, I don't think you had any other DVs or prior violent history, so you are going to be released on your own recognizance. It is going to be your promise to appear. But given the nature of the offense, you do have orders here that you are not to have any contact with the alleged victim in this matter, or any complainant or witness, which does mean you can't reside at the same location as the alleged victim. So if they are still residing at that location, you would need to find an alternate residence, at least until further court order in this matter.
Even if it's my home and I'm renting a room to him?
That is correct. You're the only one I can do any orders on here, and you have a no victim contact order.
Okay.
Okay. All right. So if you do need a return there, you are permitted to do so using a civil standby. And I just need to caution you that a violation of a no victim contact order and a criminal release order, that's what you have now, that could constitute aggravated harassment, which is a Class 6 felony.
They told me to file something against him. Can I do that?
That is a civil matter.
Okay.
That is an eviction matter.
Okay.
So you need to make sure that you're aware of what the landlord-tenant laws here are in Arizona. I saw that you did the 5-day notice.
Yeah.
But there's more to it than that.
Right.
Okay. So you can certainly speak with an attorney about that. That's not anything that I can advise you on here today, though.
Okay.
Okay.
I appreciate it.
Thank you. All right, Mr. Porter. After that will be Justin Maldonado. Okay, so your full name and date of birth.
Cash Porter, May 19, 1990.
All right, you are here for a new case out of Superior Court. This is alleging 1 count of possession of narcotic drugs, which is a Class 4 felony, 1 count of possession of drug paraphernalia, Class 6 felony. The public defender's office has been appointed to represent you. You have 2 court dates currently set at the Superior Court in downtown Phoenix. Those are a status conference May 8th, preliminary hearing May 12th, both at 8:30 a.m. The address for the court will be provided in your paperwork. I am going to be following the PSA recommendation in your matter. You are being released on your own recognizance. It is going to be your promise to appear. Do you have any questions regarding anything that I just went through?
No.
All right, if you want to go and step over, you can go and pick up that paperwork that's over there and have a seat. All right, so we have Justin Maldonado. After that, it'll be Anthony Dimitro. All right, sir, your full name and date of birth.
Justin Israel Maldonado, August 23rd, 1993, Your Honor.
All right, thank you, sir. So you are here on a child support warrant. Looks like, are you the one that's been in probate or in here for the probation, for your probation matter, or no?
No, I mean, I don't know why they put a warrant out for my child support if I've been in custody the whole entire time.
That's what I'm trying to figure out. Or you're here for a DOC hold? Which one are you here on?
No DOC hold, no.
Okay, so you're here on a probation matter?
Yes.
Okay, and you've got a term, what, until June or something?
June 23rd, but I'm being released with, I already talked to Reach Out, so they're supposed to be coming to get me in the next 2 weeks. So I'm just waiting for them to have a bed open and stuff like that.
Mm-hmm.
That's all I'm really waiting for. And I wasn't aware of my child support court. Like I knew about it, but they didn't call me to court for it.
Don't say that, because you were given the notice. I saw that you were there.
Yeah, I have it, but they didn't, yeah.
But I do recognize you were likely in custody at the time.
Yeah, and usually they'll wake me up for it.
So here's the deal for that. So if they don't know you're in custody, if you got released in your child support warrant, which is my understanding you did, I think they quashed that warrant and released you.
Okay.
And told you appeared another court date. If they don't know you're in custody on that matter, they're not going to transport you to a court date. So that's
Really?
why they didn't wake you up to go there, okay?
Wow.
And that's why they issued the warrant, because they didn't know you were in custody at the time.
Oh, wow.
Okay? So they did issue another warrant, and I don't know what your other cash purge was. This one had the cash purge in the amount of $500, okay?
Okay.
So here's what I'm going to do then. So today I'm going to go ahead and affirm the cash purge amount of $500 because I want to set another court date for you here, and that's going to be on May 2nd at 10 a.m. All right, so that should still be within the time frame you're here before you would have been released to reach out. Okay. Because that's still within like 8 days or so.
Okay.
All right. So that way you can attend this court date because they'll know you're in custody this time. Okay. So just don't post the bond. Let it sit there. They'll be able to transfer it to your court date so that way you can address that while you're still in custody. Okay.
Okay.
Because otherwise, if I release you on this and don't set this cash purge amount, recognizing that you were in custody, you'll still be in custody on this date, it looks like.
Yeah.
Okay. Because either way, you get the May 2nd court date.
Okay.
I don't want this to happen again. Otherwise, they're just going to issue another warrant for you and you're going to come right back in here again. We're just going to kind of go around in a circle. Okay.
Yeah. What time was it at?
So it's going to be May 2nd at 10 a.m.
Okay.
Okay. All right. Does that make sense to you why we're doing that?
Yeah, it does.
Okay. All right. So just go ahead and let them know you were in custody at the time the warrant was issued. So that's why you didn't appear at your last court date because they didn't know you were in custody. And that's the reason we went ahead and affirmed this cash purge amount. Okay.
Okay.
All right. Do you want to go and step over? You can go and pick up that paperwork over there. All right. So we have Anthony Dimitro. Phone in a date of birth.
For Your Honor. My name is Anthony Dimitro. This warrant I'm being detained on by California.
Can you give me your date of birth, please?
9/8/89.
All right, thank you. All right, so you are here for that warrant in California, which is a probation violation warrant. Once you were picked up on that, California was notified. They did both confirm the warrant as well as extradition in your matter, okay? So the process here is fairly set in stone as to what's going to happen here in Arizona because this is California's warrant. So as long as they're saying it's a valid warrant, we do have to recognize it here in Arizona.
California issues this warrant on me
Can you
and they
let
don't
me
come
speak?
after me.
Can you let me speak?
Yes, ma'am.
All right. So you were given that laminated sheet. Did you have an opportunity to take a look at that here today?
A little bit. I didn't have my glasses, but
All right, so if you weren't able to read it, then what we might do is just go ahead and set a hearing for you here in Arizona. But I'm going to go over your two options here today, and I'll see if you know how you want to proceed. If you do want to waive extradition, you're going to have to read that a little more thoroughly than you obviously already have, okay?
and if I waive
But I'll go ahead and give you your two options here, and then I'll see if you have questions afterwards. So why don't you let me go ahead and finish everything, and then
Yes, ma'am.
you
Go
can ask
ahead.
me any questions you have about the choices you have here.
Go
All
ahead.
right, so your first option is you can choose to waive extradition and return to the state of California on this warrant. When you do that, you are agreeing to return to California and not having any further hearings here in Maricopa County for this case. You will be held in the Maricopa County Jail without bond until California picks you up on this warrant. California, in turn, would have 30 days starting tomorrow to pick you up on this warrant, unless you have any local open cases. I'm not aware of any, but if you do have any local open cases, the 30-day time frame would not start until the conclusion of that case. So that is if you want to waive extradition and return to California. Your other option is you can choose not to waive extradition and otherwise fight the warrant, and that is your right to do so. We would be setting a fugitive of justice or an extradition hearing here in Arizona. That would take place on May 5th at 1:30. That would be at the Superior Court in downtown Phoenix. I can't appoint an attorney to represent you at that hearing because the extradition case here in Arizona is a civil matter. Even though it's a criminal case out in California, the extradition proceedings are considered to be civil matters. You do have the right to retain an attorney on your own behalf to represent you. I'll also note there are public defenders who are often present at those hearings to provide assistance, but there's no guarantee of that. This is a probation violation warrant issued out of California, so either way you are required to be held without bond. So your release conditions stay the same no matter which direction you go here today. Now the process there is that if you want to contest extradition in this matter, is that a governor's warrant has to be signed by the governors of both states, so of both California and Arizona, in order to extradite you back there. And that process can take up to 90 days, so it can be a longer process. That's the time frame they have to execute the warrant. All right, now do you have any questions regarding what you're looking at here today?
Yes, Your Honor. This warrant has been issued and served to me, and California said they did not want to pick me up.
And if they provide notice again that they are not going to pick you up, then you would be released. They're not going to hold you on a warrant that they're not going to pick you up on. But at this time, they do say, we will extradite in their response. So that is something this court has to recognize.
Is there any way that the court could take into consideration that I've been held on this warrant and that California has not picked me up on it? Because I'm going to lose my job. I got a newborn baby.
You should have taken care of this.
And I have an address.
It doesn't go away. Yeah, it doesn't go away. You're just going to keep getting picked up on it over and over again, then, if you don't go to California and take care of it. If they don't pick you up on it again. You couldn't take into consideration, Your Honor, leaving me out of my own reconnaissance and let me work and take care of my baby until they come? That's not an option here today. All right.
Okay.
Any other questions regarding this?
I'm going to waive the extradition. I'm just going to go ahead and get this done.
Okay.
They got 30 days from today?
They have 30 days starting tomorrow in order to come pick you up on the warrant, unless you have any local open cases. If you have any local open cases, the 30-day time frame has to start at the conclusion of that case.
Your Honor, do you have access to my files where it shows when California did drop that warrant?
I do not. The only thing I have here is their warrant right here, their response, and the teletype response saying that they've confirmed the warrant and that they would extradite on it.
Okay.
All right, do you want to waive extradition here today?
Yeah, I'm going to waive extradition. I ain't going to,
Do you need to read that paperwork, though? Because that is the waiver of extradition, and I can't have you sign it if you haven't actually reviewed that paperwork.
It says they got 30 days to come get me?
Please sit down and read the paperwork.
I don't have glasses, ma'am.
Then we're going to have to set the hearing for you, because you can't sign off on something if you can't read it.
Ma'am, I'm going to sign off on it. I have the right to represent myself. I don't have an attorney here present. I'm a United States citizen. Mm-hmm. I'm going to waive the extradition and get this over with.
No, I can't find that you knowingly waived extradition.
I knowingly know my constitutional rights to represent myself in this courtroom, and I'm waiving my extradition, ma'am.
I'll give you an option to go over there and review it if you believe you can review it without glasses. If you believe you are unable to review it, I cannot have you sign off on a document that you're unable to read.
Yes, ma'am. I'll go ahead and read it.
Go ahead and have a seat. All right, I'm going to go ahead and put our one house call on the record here. This is going to be for James Darnell Davis, date of birth 4/2/77, who's here on a probation violation warrant. That's for a petition to revoke filed alleging a violation of terms 3, 5, 7, and 15. The public defender's office has been appointed. Revocation arraignment hearing May 1st at 8:30. And in that matter, the bond and the warrant's been affirmed. That is a $5,000 secured appearance bond. I don't have why he was a house call. Do you know why he was a house call? Danger to self? Okay. All right, so we're going to have a clear before we do any further matters, and then we'll still have to call Mr. Demetrio in before we bring in our final matters here. As soon as Mr. Demetrio is done reading the waiver paperwork, he can come back in here and we'll do his waiver.
He's coming in here. Good night, Your Honor. Yes,
Mr. Demetrio, did you read the waiver of extradition paperwork, which is that laminated sheet that you
I
had?
did read it, ma'am, and I intelligently and voluntarily do sign it.
Did you read the waiver paperwork, yes or no?
Yes, ma'am.
All right. You understand that you do not have to sign the waiver paperwork here today?
I do understand that.
You understand that you have the right to have an extradition hearing here in Maricopa County?
I do, ma'am.
You understand that you have the right to hire an attorney at your own expense to represent you at those hearings?
I do, ma'am.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before your return to California?
I do understand.
Do you want to give up those rights I've just gone through in order to sign the waiver paperwork here today?
Yes, ma'am.
Has anyone threatened you or promised you anything in order to get you to sign the paperwork?
No, ma'am.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No, ma'am.
Right, based on those responses, I do find that you are knowingly, intelligently, voluntarily signing the waiver. I will be signing it as well, indicating you are waiving extradition in this matter. I am directing the Sheriff's Office to notify California that you are ready to return at this time. California will have 30 days from tomorrow to pick you up unless there are any local charges pending. If there are local charges pending, that 30-day time frame would not start until the conclusion of the local case. All right, if you want to go ahead and step up here, we will let you know when you need to sign. I've just signed that, Marissa. Go ahead and sign. Make sure you sign release. One more thing. Okay. Go ahead. Yeah. All right, let's go and start with Mr. Logan. All right, sir, your full name and date of birth?
Full name is Derek Davon Logan. Date of birth is 6/20/1987.
All right, thank you, sir. So you've got two separate cases here today. I'm going to start with a new case that'll be out of the Maricopa County Superior Court. The charge submitted there is one count of sexual abuse, a Class 3 felony, with an offense date of December 22 of 2022. So in this matter, the Public Defender's Office has been appointed. You do have a status conference set on April 30 with a preliminary hearing May 2nd, both at 8:30. Those will be at the Superior Court in downtown Phoenix. So in your case, I did receive a written recommendation from the state. They're actually requesting a $500,000 cash-only appearance bond in your matter based on the nature of the charge. I've also considered the victim impact statement in this matter, as well as the nature of the offense that you're here for. So in this case, I do believe a bond is appropriate. I didn't go quite as high as what the prior request was, but you do have a $250,000 cash-only appearance bond. If you post bond and are released from custody, it is going to be subject to the supervision of pretrial services with electronic monitoring as required by Arizona law. You also have orders not to have any contact with the alleged victim or any complainant or witness. You're not to return to the scene of the offense. You are not to have any contact with any minors at all at this time. Do you have any minors currently residing in your residence?
Just my kids.
All right. How old are your kids?
14 and 15.
Are they males or females?
My oldest is female. My youngest is male.
All right. At this time, I'm going to put in here a no contact with minors due to the nature of the charge you have here, and given the alleged age of the victim in this matter. So you are going to have a no contact with minors rule, which does mean you'd have to find an alternate residence if they're still at that location.
Mm-hmm.
That would be at least until further court order. Okay. Given the nature of the charge, I'm not going to change that at this point, but it doesn't mean it can't change in the future. Okay. All right, so let me go ahead and make that change to your release order here, and then we'll go ahead and go on to your next matter because it's an out-of-county child support warrant that you have here, okay?
Oh, okay.
So give me just 1 second.
Yes, ma'am.
All right, so your next matter that we have here is that out-of-county warrant that's out of the Pinal County Superior Court. This is a child support arrest warrant, so it's a civil arrest warrant that was issued out of that court. So in Arizona, I cannot legally reduce a child support warrant order that is set by your family court judge in that matter. However, I do have to ask you some questions here that's required by law. You can answer them if you want to, but you do not have to answer either one of these. Is there anything you want the court to know about your present ability to pay the cash purge? And is there anything you want the court to know about being held in custody until that cash purge is paid?
How much is the cash purge?
It is a $400 cash purge.
Okay. I can pay it. I have a job right now, and I've been paying for the last year and a half. Yeah, that's pretty much it. So.
Okay. All right. So here's the deal on that. So we're going to set an arraignment hearing April 29 at 8:30. That would be at the Pinal County Superior Court.
Okay.
If you were still in custody in this matter, and only this matter, then they would need to come and transport you out there to attend your court date. If you're released from this matter and don't have any other pending matters, then you would just need to make sure you show up for your court date out there. Okay, so whether you pay that cash purge or not, either way, you do have a court date. Okay. Now, I'm kind of hedging on that a little bit as far as when your court date's going to be, because you do have this other potential open case. From here, the charges that were submitted to the court here today do go to the charging agency, whether that's the Attorney General's office or the county attorney's office, and they make a charging decision. If charges are filed in this matter, you will still be in custody if you haven't posted your bond in that case, and this date could change, your Pinal County case date. Okay? So if that does happen, you might want to just leave that cash purge in place just until you know what's going on with this other matter. That way they know you're in custody in this matter too. Okay? All right, do you have any questions regarding that?
No, ma'am.
All right, if you want to step over, you'll get paperwork for both of those cases.
Thank you.
All right, so we've got Brett, Ray, and then Alfonso Logan will be up next. All right, sir, your full name and date of birth.
Brett Ray, 6891.
All right, so you are here for a new case out of Superior Court. It is alleging 2 counts of sexual exploitation of a minor. That's a Class 2 felony, and 1 count of sex offender online identifier in violation. That's a Class 4 felony. So in this matter, the public defender's office has been appointed. You have a status conference currently set on April 30 with a preliminary hearing May 2nd, both at 8:30. Those are going to be at the Superior Court in downtown Phoenix. In this case, based on review of your history, as well as the nature of the offense you have here, you do have a bond in this matter. That's a $150,000 cash-only appearance bond.
Okay.
Now, if you post bond, if you post bond and are released from custody, it would also be subject to the supervision of pretrial services. You'd also have electronic monitoring installed prior to your release from any facility. It's required by Arizona law. What did you have a question about with respect to the bond?
I was wondering, how much does my mom have to put up to...
So you have a cash bond here. That means that full amount does have to be posted. This is different than a secured appearance bond where you can do that percentage with security. As far as whether you can have a bail bonding company work with you to assist you in posting that cash bond, you would have to contact them.
Okay.
But otherwise, it's a little different than the secured appearance bond.
Okay.
Okay. All right. So you're also going to have orders not to have any contact with any alleged complainant witness, and you're not to have any contact with any minors. Do you currently have any minors residing in your residence? Okay. We'll leave that as is without any notes. You are going to receive that information here in a moment in your paperwork. Any other questions, though, before you go?
No, I just really need to see medical and go to the bathroom.
All right, so when you go through intake, we'll let them know you need to use the restroom. There's restrooms out there. But when you go through intake, they're going to talk to you or ask you about any medical issues that you have that need to be addressed. And if there's anything that correctional health needs to address, I just
have SVT and type 1 diabetic.
All right, let them know, especially if you have any prescription medications that need to be taken care of, okay?
All right.
All right, thank you, sir.
I have no business.
All right, sir, if you could just step up to the podium and state your full name and date of birth. Your full name and date of birth.
Huh?
Your full name and date of birth.
I can't hear what you said.
Let me get you the headphones.
I'm TTY certified.
Hold on. Can you hear with the headphones?
No, yeah.
All right, is that better? No, pull it away. Yeah, just keep it away from the microphone there. All right, is that better? Can you hear me?
Yeah.
Okay. Sir, if you could state your full name, your date of birth.
My name is Victor Alfonso Herrera Lopez. I was born in Havana, Cuba, September 30, 1959. I'm currently disabled. I can't work. I'm sick. I got asthma. I got 7 years to live.
All right, hold on. You're getting ahead of yourself here. So I needed to let you know why you're here today, okay? You are here because there is a new charge out of the Maricopa County Superior Court. It's been submitted. It's 1 count of sex offender registration violation. That's a class 4 felony. So in this matter,
I was on my way to register that day.
Hold on. The Public Defender's Office has been appointed. And in this matter, you have 2 court dates currently set. That's a status conference April 30 and a preliminary hearing May 2nd. Those are both going to be at 8:30 a.m. So in this case, based on the nature of the offense, you do have a bond in this matter. That's a $2,500 secured appearance bond. If you did postpone and were released from custody, it would be subject to the supervision of pretrial services with electronic monitoring to be added prior to your release from any facility. So in this matter, you will receive that paperwork. It's going to have all that information. You did indicate that you do have some disability issues. If you do have any ongoing medical issues that need to be addressed, you need to let them know during intake so that the jail is aware of them if you don't postpone. All right, do you have any questions regarding this?
I was on my way to see the judge to register that day.
Yeah, there's no indication.
And the bus got broke down.
And you've not been registered for over a year. I think it said 2 years. So in this case, probable cause was found for the charge, and at this time you do have a bond. All right. Any other questions regarding that? All right, sir, if you want to go ahead and step over, everything will be in your paperwork as well there. Thank you. All right, so we already put our house call on the record. Let me go ahead and log out of here. And then whenever you're set, I'll come around and join you. Oh, I didn't log off the recorder. Can you?
All right.
All right, thank you. Please be seated. Booting this every night, very annoying. Every single night. Sorry, I have to log in. All right, this is the 11 a.m. initial appearance calendar for April 24th, 2025. The court's orders for the taking of fingerprints and DNA samples made on the 2 a.m. calendar on the 1st of the month will also apply, will also apply to these hearings. First up is going to be Mr. Walker, Josiah Walker. If you please come all the way to the podium right here. You're going to be first, sir. After that, Giovanni Lopez Uriostegui. Will you please go to the chair? You'll be next. Hello, Mr. Walker. Can I have your full name and your date of birth, please?
Josiah Walker, 4/19/2000.
All right, thank you. You're here on a new case. You were arrested for possession of narcotic drugs. That's a Class 4 felony. And possession of drug paraphernalia. That is a Class 6 felony. There is probable cause for those, and the court is appointing a lawyer to represent you in this case. I'm scheduling 2 court hearings. Actually, I'm scheduling 3 court hearings for you. I'll tell you what they are. The first one is a status conference in the Downtown Superior Court, April 30th, which is 6 days from now. The court address downtown is on your paperwork. Your preliminary hearing will be in the same court on May 2nd at 8:30 in the morning. Now, in between those, you're going to have a bail eligibility hearing. The reason you need a bail eligibility hearing is that there's probable cause for new felonies while you have any pending felony case. Your pending felony case is the case that you were in a diversion program for. That's CR 2025-105978. Your first court hearing in that case was February 6th of this year. The law says that does count as a pending case. So when you come in with probable cause for a new felony while you have a pending case, you cannot be given bail at this hearing. You must be held for a bail hearing. So I'm scheduling that for you for 1 week from today. May 1st, 1:30 in the afternoon. It is an evidentiary hearing, so when you see it on your paperwork, that evidentiary hearing is your bail hearing. You may or may not be found eligible for bail in a week, but you're not eligible today. You are going to be held. You should end up with the same lawyer for both cases, and you'll see that person the day before the bail hearing. All right, we're going to go ahead and get you your paperwork. Officer, do you have that form? Here, grab that from the officer. You'll be all done. You can step out to your left. Thank you, sir. Mr. Lopez, if you'll come in, then Jesse Martinez, will you go to the chair? Hello, sir. May I have your full name and your date of birth, please?
Giovanni Lopez Uriostegui, September 15, 2001.
All right, thank you. You're before the court on 3 matters. You need to sit right there on the chair. See, just inside the door. Thank you. Just wait right there. Thank you. All right, sir, 3 matters. The first one is a new arrest from yesterday. You've been accused of possessing narcotic drugs for sale. That's a Class 2 felony. And unlawful flight from a law enforcement vehicle. That is a Class 5 felony. There is probable cause for both of those, and I am appointing a lawyer to represent you. I'm also appointing a lawyer for you in both of your probation cases. You're on probation for 1 felony and multiple misdemeanors in I guess they're both 2022 cases. In one of your probation cases, in the other probation case, you're on probation for a Class 5 felony, namely unlawful flight from a law enforcement vehicle. All right. So you should have the same lawyer for everything, ultimately. I'm going to give you your court dates now. In the brand new case from yesterday, your status conference will be April 30th at 8:30 in the morning. The preliminary hearing, May 2nd at 8:30. Those will both be in the Downtown Superior Court. In each of your 2 probation cases, you are going to go to probation court on May 1st at 8:30 in the morning for a revocation arraignment and possible disposition hearing. And in each of your probation cases, it is ordered holding you without bail because you will, in all reasonable probability, be revoked to prison in one or both of those cases. So you do not have bail today in your probation matters. In the new case, you have a $10,000 secured appearance bond and written release conditions, but you shouldn't try to post that bond if you are still being held without bond in any of your probation matters. So you should end up with the same lawyer for everything, and if you take your paperwork, you'll be back in court next week, okay? Thank you. All right, Mr. Martinez, Jesse Martinez. All right, sir, can I have your full name and your date of birth, please?
Jesse Dylan Martinez, 9/13/1989.
All right, thank you. Mr. Martinez, you are here on a probation warrant. You're on probation for a Class 4 felony, and back on April 14th of this year, there was a warrant issued for your arrest after another petition to revoke your probation was filed. It alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your next court date is going to be in the downtown probation court, May 1st at 8:30 in the morning. That is a revocation arraignment and possible disposition hearing. I am affirming the order of the probation judge, which is that you are to be held without bond in this case because in all reasonable probability, you're going to be revoked to prison. It doesn't mean you are, but it means that there's a high likelihood. So you don't get bail. But we're going to give you your paperwork, and you'll be back in court next week.
That's the only charge?
Probation violation, correct. All right, so officer's got your paperwork for you. Just grab that from him. Thank you very much. Ms. Wheeler, Sherry Wheeler, will you come in? Sherry? Sherry? She's asleep. Sherry's got a plaid shirt on. She's got bright pink hair right there. Come in, ma'am. All right, then Jason Green, will you go wait in the chair, please? All right. Hello, ma'am. Can I have your full name and your date of birth, please?
Sherry Michelle Wheeler, 6/9/89.
All right, thank you. You're here on two matters. One's a probation warrant from this county. One's a probation warrant from Yavapai County. In Yavapai County, pardon me, looks like you're on probation for fraud schemes, a Class 2 felony. And there appears to have been a petition to revoke filed up there for you. A warrant issued for your arrest on August 22nd of 2023. We're going to let them know they should give you a lawyer when you get there. And your court date in Yavapai is scheduled for April 29th at 8:30 in the morning. That is 5 days from today up in Yavapai County. I am affirming their bail amount. It is $25,000 secured with written release conditions. In Maricopa County, there was a petition to revoke your probation filed on August 21st of 2023. That petition alleges that you violated terms 6, 7, 11, 12, and 14. I am appointing a Maricopa County public defender to represent you in this case here in Maricopa County. Your court date here in Maricopa is May 1st at 8:30 in the morning in the downtown probation court for a revocation arraignment and possible disposition hearing. In the Maricopa case, I'm setting bail in the amount of $500 secured. So your total bond across the two cases is $25,500. If you bond out, comply with all of your written conditions, don't miss your court dates, call your probation officer within 72 hours. The main number is on your paperwork. He's got that for you. Thank you very much. Screen. Next up, Michael Nelson, will you go to the chair? Hello, sir. Can I have your full name and date of birth, please?
Jason Green, 2574.
All right, thank you, sir. You are here on a new case. You were arrested for possession of narcotic drugs for sale, a Class 2 felony, possession of narcotic drugs, a Class 4 felony, possession of drug paraphernalia, a Class 6 felony, and driving under the influence of alcohol or drugs while impaired to the slightest degree. That is a Class 1 misdemeanor. There is probable cause for all of those, and I am appointing a lawyer for you in this case. You are also here on a probation hold because the probation department will be filing a petition to revoke your felony probation based on this new arrest. So you will have a lawyer for both, should be the same person. All right, your next court date in the new case is April 30th. The status conference, April 30th, 8:30 in the morning, with a preliminary hearing May 2nd at 8:30. That'll be in the downtown Superior Court. In between, though, you're going to go to probation court for a revocation arraignment and possible disposition hearing. That'll be May 1st at 8:30 in the morning, again in the downtown Superior Court. Bond is set in each of these two cases at $5,000 secured. That is $10,000 total If you bond out, you must comply with all of your written release conditions. Do not miss your court dates. Everything's going to be on your paperwork. Just take that from him. Thank you very much. Mr. Nelson, Michael Nelson. Where's Mr. Nelson? He's dressed out. He's sleeping. He's got his chin on his chest right there, sleeping. Yep, that's the guy. Mr. Nelson. Michael Nelson. And then Sarah Dyson. When you go to the chair, you'll be after Mr. Nelson. Right there at the podium, please. Hello, sir. May I have your full name and your date of birth, please?
Michael Douglas Nelson, 8/16/82.
Thank you, Mr. Nelson. You're here on a new case. You were arrested on these allegations. Aggravated assault on a first responder, that is a Class 4 felony. Resisting arrest, a Class 6 felony. And criminal trespassing as a Class 3 misdemeanor. There is probable cause for all of those. The police also booked you on one allegation of possession of dangerous drugs for sale, which is a Class 2 felony. But for purposes of this hearing only, the court does not... Wait, sir, please.
Oh, sorry.
The court does not find probable cause for the drug sales.
Okay.
So, it is still pending against you, but I'm not setting release conditions on that basis. You can talk to your lawyer about how that works. That charge is not dismissed. It is pending against you. I'm just not setting release conditions for it. The bond I'm about to set would absolutely have been higher had I found probable cause. So talk to your lawyer about how that works. I'm giving you a lawyer, and I'm giving you 2 court dates. The first is a status conference, April 30th at 8:30 in the morning, with a preliminary hearing May 2nd at 8:30 in the same court. For the reasons set forth in my written order, bond is set in your case at $1,000. It is secured. If you bond out, comply with all of your written release conditions. Do not miss your court dates. Everything is on your paperwork. We're going to get you a copy of that. Good luck. Ms. Johnson? And Juan Gutierrez, we go to the chair. And hold on one second, ma'am. Let me just ask. Counsel for this day, are you here only for the matter that there's a defense attorney here for? If so, I'll have the DOs give him a heads up and we can move this along. I was just kind of letting him sit there. But if that's the only thing you're here for, I could call that case.
Oh, thank you, Your Honor. That is the only case I'm here for.
Okay, thanks. Do you mind just letting the defense attorney know that I'm going to want to go on his case within the next few minutes unless he wants to ask me for more time? All right, ma'am, can I have your full name and your date of birth, please?
Sarah Jane Dislin, 8/29/83.
Okay, thank you. Ms. Dislin, you're here on, let's see, 2 probation warrants that issued in your felony probation cases on December 13th of 2024. In these cases, in each of them, there's been a petition to revoke filed that alleges that you violated terms 3, 5, and 15. You'll get copies of those from your lawyer, and I am appointing a lawyer for you in both cases. Your court date in probation court is May 1st at 8:30 in the morning. That's going to be a revocation arraignment and possible disposition hearing in the downtown Superior Court. And I'm going to affirm the bond set by the probation judge. In number 35 on the calendar, which is the theft case, it is a $1,000 secured appearance bond. In number 34 on the calendar, which I believe is a drug case, that is a $500 secured appearance bond. So your total bond is $1,500 secured with release conditions. Be sure to call your PO within 72 hours if you do make bond. If you accept your luck, the officer has your paperwork. Thank you. Mr. Gutierrez. And then Chastity Benally, please go to the chair. Great. He can go, just let him stop right there. I'll do him right after this guy. Ms. Benally, stay where you are next, okay? All right, sir, can I have your full name and date of birth, please?
Juan Gutierrez, 11/29/1975.
All right, thanks. You're here on a warrant. In a pending case, you've been charged in the case with dangerous drug possession, Class 4 felony. This warrant issued on March 15th of 2022 after you failed to appear at a status conference. You've already had a lawyer appointed. We're going to reschedule that status conference for April 30th at 8:30 in the morning in the downtown Superior Court. Bond is set in your case at $1,000. It is secured. If you bond out, comply with all of your written conditions. Do not miss your court date. You step to your left, this gentleman has your paperwork. All right, let's get Mr. Allred in here. Get my camera on. All right, so you can just go ahead and come up, counsel. Yeah, sorry, ma'am. We're gonna do this case first. Yeah, go ahead and have a seat, ma'am. All right. Okay, and just so you know, I do have the county attorney appearing virtually. You'll be able to hear him. I'll be able to see him. All right. This is going to be Let me get back to the right case card. This is going to be Mr. Clark. Okay, all right. And counsel, just a heads up, remember to push the button on the microphone, even if you're whispering. There's a seat right there in front of you, counsel. Yeah, just if you want to talk to your client, I just recommend that. We do live stream on the internet. Okay. So you don't know what that mic is picking up. All right, Mr. Clark, we'll start with your full name and date of birth, please.
Blake Clark, April 17th, 1985.
Thank you. And then the appearance of the state, please.
Good morning, Your Honor. Stephen Garcia on behalf of the state.
Thank you. And defense.
Good morning, Your Honor. Michael Allard III, appearing on behalf of Blake Clark.
All right, thank you. Mr. Clark, you've been arrested on the following allegations. Disorderly conduct with a weapon, a Class 6 felony. Disorderly conduct as a Class 1 misdemeanor, and assault as a Class 2 misdemeanor. And based on what the police submitted, counsel, the court is inclined to find probable cause. Did you want to be heard on that before I make a ruling?
The only one I would want to be heard on is with regard to the assault charge in that count. Even taking the Form 4 at face value, I don't see any possible interpretation of the allegations that they could meet any definition of assault. In this particular case, there's no allegation that there was any physical touch against the victim or placing the victim in reasonable apprehension of personal physical harm. So even if you were to believe all of the allegations in the form, I don't see how you find probable cause on the assault charge.
All right, thank you. Mr. Clark, I've considered what your lawyer had to say and what the police alleged, and the court simply disagrees, counsel. The court believes that on the totality of those facts, that most people would be in fear for their own safety, in addition to the safety of the person who was doing that thing in front of them. And so reasonable minds can differ on that. Probable cause is also a very low standard. It is, in fact, below preponderance of the evidence. So I do find probable cause for it. Ultimately, what will matter is what the county attorney may choose to charge you with. And your lawyer can go over that when that decision is made. So for purposes of this hearing, the court does find probable cause on all of these allegations. Counsel, I saw you noticed in limited only. Should I go ahead and appoint for him? I believe he did. Double check. He does qualify. I'm not sure he took the that he did the financial profile.
No, Your Honor. I know that's my standard form, but I can be on the case moving forward.
Okay. All right. Then let me just change that to not indigent. All right. And so just so you know, Mr. Clark and your lawyer can explain it to you. If at any time you wish to attempt to qualify for indigent counsel, you can fill out the paperwork at a later hearing. I'm just not appointing a lawyer for you today. All right. I'm going to give you your court dates in a moment. Before I do that, I'm going to take release recommendations, and I'm going to start with the state.
Thank you, Your Honor. Your Honor, state is requesting a $5,000 secured appearance bond. It does appear he does have one prior felony conviction, an attempt crime from 2022, a Class 6 felony. He also has a fairly dated, but more to it, Your Honor. We feel that this was a highly dangerous situation, volatile situation that the defendant created by essentially taking a weapon and what seemed to be a threat that he might shoot himself, and obviously it was an ongoing situation where he was essentially berating his wife at the same time. Thank you, Your Honor.
Thank you. Mr. Ullery.
Your Honor, in terms of his criminal history, it's very limited. I think it's important to point out that the one felony conviction that he does have on his record from 2022 is an attempt, and it's a counterfeit issue, and really it has to do with trademark regarding his business. So it's not a violent offense or having anything to do with that. It was also recently sealed, as far as I know, from a previous set-aside.
His civil rights restored 9/7/2023.
Yeah, so his civil rights were restored, and then it was set aside. In fact, I think just last week or the week prior. So very recently, it was set aside. In addition to that, the one misdemeanor assault from 2007, which is very long in the past, and shouldn't have any bearing on this particular case. Obviously, he denies the allegations. This isn't a proper venue to have issues regarding the facts, and this isn't a trial, and that's all fine. But as far as his failure to appear, he has no failure to appear. He's not a risk to himself or the community at this time. As you will note, the date of the alleged violation is from April 16th. He wasn't contacted until yesterday and taken into custody, so a substantial period of time went by. There was obviously no issues between now and then. As far as the state's allegation that he's an ongoing risk to the victim, who was his wife, who was present at the time, it's important to point out that she's already moved out of the residence. She has rented a place and has already signed a year lease. So she is no longer at that residence. So there shouldn't be any issues with him returning to the residence or having any contact with her while this case is pending without, legal counsel being involved in that contact. So we don't have any issues there. So our recommendation would be, since there's very limited criminal history, since there's no risk to the victim given that she's moved out of the residence, signed a lease somewhere else, he should be released on his own recognizance. I think it's also important to point out that he's a homeowner here in Arizona. He owns a business. He has many employees that work for him in his real estate business, and he has to travel for work quite extensively. So I would ask that he be released on his own recognizance and be allowed to return to the residence, have no contact with the victim without legal counsel being involved. And other than that, I don't think that there's any additional release conditions that should be placed on him.
Right, thank you. Mr. Clark, I've considered what's been alleged against you and the recommendations of both lawyers as well as your criminal history. And I will say, this court believes that there are many, many, many red flags for domestic violence and an elevated lethality risk to this alleged victim. I absolutely disagree that what's been alleged against you does not demonstrate a strong risk to this alleged victim. I have also considered the victim impact statement, just for purposes of that. In fact, I believe the facts likely support a higher bond in order to try to get a compliance with court orders. But the state's recommending $5,000, which frankly surprised me. I will say that statistically speaking, all research supports that domestic violence is a high predictor, allegations of domestic violence, for violation of release conditions. This court is extremely concerned about these allegations. They exhibit the kind of ownership and control issues, and that even under these facts, where somebody is threatening themselves on these facts, that person is at a high likelihood of violating release conditions. I can't overemphasize, Mr. Clark, that the court is very concerned about you complying with release conditions. So I'm going to set bail in the amount recommended by the state, which is $5,000 secured, and I'm going to put an ankle monitor on you, because release conditions are intended to protect the community and assure your appearance throughout the entirety of the case. And there is a high rate of violation of release conditions in domestic violence cases. So the purpose of the ankle monitor, it will not interfere from you working. It is to keep you honest about categorically staying away from the alleged victim. This order does not apply to your children. If your spouse gets an order of protection that does apply to your child or children, then that will apply. This one does not, but you are not permitted to violate this order in order to have contact with your children. And so, this court orders absolutely no contact with her. If you cannot find a way to do it without contacting her, you may not violate this order in order to exercise your parenting rights. You talk to your lawyer about your overall problem. You do not just give yourself permission to violate this order because you want to see your children. Absolutely no weapons. You are ordered to surrender all firearms in your possession to a local police agency within 24 hours of release from jail. Provide proof to the court at your next court date. Obey any order of protection that's been served on you. Anything else from the state?
No, thank you, Your Honor.
All right, Mr. Ali.
No, nothing else.
All right, we're going to get that printed up. If you want to keep using the room, Mr. Allred, no problem. I just wanted to be able to get Mr. Garcia out of here.
That's fine.
And you're welcome to disconnect when you're ready, Mr. Garcia. Have a good day.
Thank you.
Thank you. All right, let's go to... We're at Ms. Benally, Chastity Benally. Is that who was there?
Yes.
Okay, great. Let's have her come in, please. And then Irish Oligschlager, please go to the chair. Hello, ma'am. Can I have your full name and your date of birth, please?
Chastity Benally, 12/9/90.
12/9 of 80?
90.
90, thank you. All right, you're here on one new case, and a probation warrant. In the new case, you were arrested for possessing narcotic drugs, a Class 4 felony, and drug paraphernalia, a Class 6 felony. There is probable cause for those, and I am appointing a lawyer for you in this case and in your probation case. In the probation case, you were already in revocation proceedings, and you failed to appear at a non-witness violation hearing on March 11th of this year, and a warrant was issued for your arrest. So, in the new case from yesterday, I'm giving you 2 court dates. That's a status conference April 30th, 8:30 in the morning, and a preliminary hearing May 2nd at 8:30 in the morning. Both of those are next week. In the probation case, you'll go in between those on May 1st at 8:30 for a non-witness violation hearing and possible disposition hearing. In the probation case, I am setting bond in the amount of $750 secured. In your new case, it is $500 secured for $1,250 total. If you do bond out, be sure to comply with all of your written conditions and call your PO within 72 hours of release. If that's your left, you can get a copy of that paperwork. Thank you. Or Ms. Yeah, I think you just passed him as he's bringing them to you. Ms. Oleg Schlager, then Francisco Martinez, we go to the chair. Hi, ma'am. Can I have your full name and your date of birth, please?
Prior Chicago Schlager, 4966.
All right, thank you. You're on a probation warrant. You're on probation for a Class 4 felony. And there was a petition to revoke your probation filed. It alleges that you violated terms 3, 5, and 15. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your court date in probation court is May 1st at 8:30 in the morning. That is 1 week from today. The address for the probation court will be on your paperwork. Your bond is $750. It is secured. And if you'll step to your left, they're going to give you a copy of your paperwork. Thank you. All right, Mr. Martinez, Francisco Martinez. Where's Mr. Martinez? After that, Kennedy Davis. We go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
Francisco Martinez, 1980. September 19, 1980.
All right, thank you. You are here on a probation violation warrant. You're on probation for a Class 5 felony, and there was a petition to revoke your probation filed back on February 26th. It alleges that you violated terms 3, 4, 5, and 15. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your court date is a revocation arraignment and possible disposition hearing May 1st at 8:30 in the morning. Your bond is $750 secured. If you bond out, comply with all of your conditions. Call your PO within 24 hours of release. I put 72 on your paperwork, but I just spotted that you're on IPS, so you are already obligated to call them within 24. My order doesn't give you permission not to call them within 24. All right, go ahead and step to your left. You get paperwork. Ms. Davis, Kennedy Davis, and then Sandra Harris. We go to the chair. Hello, ma'am. May I have your full name and your date of birth, please?
Kennedy Davis, 10694.
Thank you. Here on an arrest warrant. Because the county attorney has filed some new charges against you, those were filed yesterday. They are possession of dangerous drugs, a Class 4 felony, and possession of drug paraphernalia, a Class 6 felony. The alleged offense date is back on January 10th of this year, and it looks like it comes out of the Glendale Police Department. If that doesn't ring a bell, you will get police reports and a copy of the charges from your lawyer. I'm appointing a lawyer for you. And it looks like you're already in probation proceedings.
I was in county.
Yeah, no, so I don't think you have any pending cases besides this. So, anyway, I was going to say you'll have the same lawyer, but no, the probation, the people assigned solely to probation court, they don't do the trial cases, so you're going to get a trial lawyer. So, and then they'll probably end up with your probation cases.
Okay.
So, alrighty, your court date is going to be status conference April 30th. That is this coming Wednesday, and your preliminary hearing will be Friday, May 2nd at 8:30 in the morning. Those are in the downtown Superior Court, and I'm just going to set a $50 placeholder bond in this case. Don't post it unless you're sure you're going to get out in everything. It makes you eligible for credit in this case, starting today, and it ensures that they will take you over for these court dates so you don't catch a warrant while you're literally sitting at a straight up.
Right.
So everything's on your paperwork. Just don't post this unless you're sure you're getting out on everything.
Okay.
All right, everything's on your paperwork.
Thank you.
Thank you. All right, Ms. Harris, Sandra Harris. Hello, ma'am. Can I have your full name and your date of birth, please?
Sandra Harris, July 5th, 1991.
All right, ma'am. Can I have your... Sorry. I apologize. I got distracted. All right, you're here on a warrant in your probation case. You're already in probation proceedings, and you failed to appear to revocation arraignment on March 10th of 2025. You have already had a lawyer appointed. Your next court date is going to be a revocation arraignment and possible disposition hearing a week from tomorrow, which is Friday, May 1st at 8:30 in the morning in the downtown. I apologize. It is a week from today, Thursday, May 1st, 8:30. Which is a revocation arraignment and possible disposition hearing. Your bond is $500. It is secured. If you bond out, comply with all of your conditions and call your PO within 72 hours. If you step to left, you get a comment. I'm not being released. I'm not unless you post 500. Good luck, man. All right. Ms. Cronbach?
So I'm not going home?
Where's Crystal Cronbach? And then Rocky Villalba, will you go to the chair? Hello, ma'am. Can I have your full name and your date of birth, please?
Crystal Cronbach, February 3rd, 1982.
All right, ma'am. Can I, let's see. No, all right. You're on 2 warrants. It looks like. Number 23 on the calendar, I believe, is a probation warrant. No, it's a pending case. You failed to appear at a status conference on November 21st of last year. You've been charged in this case with possessing dangerous drugs, a Class 4 felony, possessing drug paraphernalia, a Class 6 felony, and refusing to provide a truthful name and lawfully detained. That's a Class 2 misdemeanor. You already have a lawyer appointed in this case and in your other case. That's the 2025 case. No, I'm sorry. This one is newly filed. Okay. So since you've been on warrant status, you've been charged in another case, but it actually dates back to March of last year. So the charge is possessing dangerous drugs, a Class 4 felony. The alleged offense date is March 7th of 2024, so a full year ago. And this comes out of the Buckeye Police Department. If that doesn't ring a bell, you will get a copy of the police reports and the charge from your lawyer. You're going to end up with the same lawyer for both cases.
Okay.
All right. So I think I can give you the same next court dates. Yeah, I can. So for both cases, your next court date is the status conference this coming Wednesday, April 30th at 8:30 in the morning, with your preliminary hearing Friday, May 2nd at 8:30 in the morning. That's both cases. And in the older case, the bench warrant case, I'm going to affirm the bond. It's $500 secured. In the newly filed case, I'm going to set a $50 bond to make you eligible for credit for time in custody. So your total bond for the 2 cases is $550. If you bond out, be sure to comply with your conditions and don't miss your court dates. Okay? He's got your paper for you. Thank you. All right, Mr. Villalba? And then Tyler Phillips, and please go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
Rocky Villalba, 6695.
All right, thank you. You're here on a probation warrant and also a warrant from the Youngtown City Court. So I'm going to start with your probation warrant. You're on probation for a Class 6 felony, and there was a petition to revoke your probation filed on April 1st. It alleges that you violated terms 3 and 5. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. Your next court date in the downtown probation court is 1 week from today, May 1st, 8:30 in the morning. That's a revocation arraignment and possible disposition hearing. Your bond is $250 secured. In the Youngtown City Court, you've been charged with criminal trespassing, Class 3 misdemeanor. This is a failure to appear warrant that issued for you on March 13th of this year. No, I apologize. It's an initial arrest warrant. So I'm going to set your arraignment hearing in Youngtown City Court for May 8th. That is not 10 days, is it? 1 second, okay? That can't be 10 days. Nope. Hold on. April 24th? Nope. All right, can we move that, or shall I just release it? That's Youngtown. I wonder if that's a mistake, because they put May 8th for both days. Or else Youngtown told them that. All right, so I got to figure it out, only because it's not going to change the $250 in your probation case. You have a $250 bond in your probation case no matter what. But in the Youngtown case, the court date is coming up longer than 10 days out, which means I cannot put a bond on you legally. We're going to see if it's a mistake in our system. So I should call him back up. She's going to have to check in the back to see if it's a mistake. So have a seat, Mr. Villalba. I'll call you back up. All right, Tyler Phillips, will you go to the chair?
I think Tyler Phillips is Youngtown.
Is he? Yeah, okay, Mr. Phillips, I apologize. You're Youngtown also.
Yeah.
So we have the same date problem. I think so either somebody made a mistake when they entered the dates in the system because it's not within 10 days.
Okay.
If it's not a mistake, then yay for you, because it means I have to release you by law, which I was not planning to do.
Okay.
So we're checking to find out if it's just a data entry error or if Youngtown, because sometimes the city courts, they go, our judge is on vacation. No hearings then.
Yeah.
In which case, you just got lucky.
Yeah.
So go ahead and have a seat. We're going to figure it out.
Yes, ma'am.
Okay.
Thank you. Back over here.
Yeah, thank you. Mr. Martinez, Mario Martinez. And then Caitlin Anderson, will you go to the chair? So, sir, can I have your full name and your date of birth, please?
Mario Martinez, March 27, 1982.
Okay, thanks. You're here on a probation violation warrant. You're on probation for a felony. There was a petition to revoke your probation filed on February 3rd, and that petition alleges that you violated terms 3, 4, 5, and 7. You'll get a copy of it from your lawyer, and I am appointing a lawyer for you. The next court date is in the downtown probation court 1 week from today, which is May 1st at 8:30 in the morning for a revocation arraignment and possible disposition hearing. Your bond is $250 secured. If you bond out, comply with your conditions, and call your POs in 72 hours. You got your paperwork.
Thank you.
Thank you. Ms. Anderson, and then Travis Newton, will you please go to the chair? Mr. Newton, Travis Newton. Hi, ma'am. Can I have your full name and your date of birth, please?
Caitlin Jane Anderson, 7/22 of 1997.
Thank you. You're back in court because the county attorney has filed some new charges against you. And I believe that was yesterday. No, 2 days ago. They took your case to the grand jury, actually. And the grand jury heard evidence and found probable cause to charge you with possessing dangerous and narcotic drugs, both Class 4 felonies, and drug paraphernalia, a Class 6 felony, back on September 30th of 2024. All I know about it is it comes out of the Glendale Police Department. But if that doesn't ring any bells, you'll get a copy of the charges and police reports from your lawyer. You're going to end up with the same lawyer that you have for your open case or cases. So you need to be arraigned on this because you've been indicted. So your next procedural hearing is an arraignment. That's going to be May 1st, 8:30 in the morning in the downtown Superior Court. And in this case, I don't think additional bond is required. So I'm going to set a $50 placeholder bond. It looks like the grand jury court did order a $2,500 bond on the theory that you've got a bad problem in multiple open cases. That being said, this is an older case. It is a drug possession case. If it was a victim case, I would probably disagree, I'd probably agree and give you more of a bond. Obviously, you don't have whatever bond money has been put on you, so I don't believe that more bond is legally supported. So the $50 is called a placeholder because it makes you eligible for credit in this case starting today.
Okay.
And it ensures that you'll be taken to all of the court hearings for this case, because if you're technically released in a case but stuck in on other ones, MCSO won't take you to any hearings in which you're technically released. So you have to have some bond on the books, or they'll leave you in Estrella and you'll catch a warrant. They'll wake you up at 2 in the morning and bring you to a judge here.
Okay.
So don't do that to yourself. Don't post a 50 unless you're sure you're getting out on everything.
Okay. I have a question. Pretrial services did tell me, and you just said too, it was, this was on September 30th. Those are the charges that I'm here for.
This is 776, and you're here, well, it looks like you have
3.
You got a theft case, you've got...
No, I'm talking about the drug charges.
Right, I know. So you've got open case 2025, pod, let me look at that, 136.
So I'm confused.
You know what may have happened? I have a thought. Let me just look at it. Okay.
Because I was indicted on those too, so that's why I'm so confused here.
Well, and what can happen? Hold on, I need to cough. They may have gone back to grand jury to correct something in their presentation, to tweak the charges somehow. I don't know. So I will tell you, I'm looking at a pending indictment with an offense date of August 29th of 2024. So that's a month before. And this is in your case that ends in 776. Here, 2025-006-776. You have been indicted in that case. The offense date is August 29. And then you've also got... Wait a minute. Okay, hold on a second. Just give me a second. Yeah, there was some weirdness. Okay, I'm just going to spend 1 minute trying to figure this out, because otherwise you're going to have to...
Okay, because I really am genuinely confused here.
So this case, I'm seeing you in 776. And when I open this, it is sealed. So I said the wrong case number. Okay. So this case ends in 776. Your offense date alleged in this case is September 30th of last year. When I look at the one that ends in 253, this one, you have indeed been indicted, and I'm going to look at the indictment from February 24th. And in that case, it is theft, trafficking, and stolen property, and that's the December 2023 to January 2024, so that's a totally different case.
Right.
Then there is the one that ends in 136. And in 136, you have been indicted, and the indictment from February 25th of this year says it's dangerous drugs, narcotic drugs, drug paraphernalia, August 29th. So this is yet another case. It's September 30th.
Okay.
Out of Glendale. And I don't know if this was also out of Glendale.
Yeah, it was.
But it is a different offense date. And so sometimes you may have been contacted but not arrested. Who even knows?
Okay.
You need the police reports.
Right.
And you guys can pour over it and see exactly what you're being accused of. But it looks like it's a full month apart.
Okay.
All right. If you step to your left, you take your paperwork.
Okay, thank you so much.
Mr. Newton. And then Jay Leija, will you go to the sheriff? Hello, sir. Can I have your full name and your date of birth, please?
Travis Newton, 8177.
Okay, thank you. You're here on a family court warrant for failure to pay child support. And in this case, it issued March 3rd of 2021. What you have is a cash purge amount and a court date. That's all. Oh, you're having trouble? Officer, can you just shut the door a little bit to kill the echo?
I'm sorry, I can't hear.
It's totally okay. Hold on. It happens to everybody. This room was not really built for the way we ended up having to do things post-COVID. Does that help, or would you like headphones? You want some headphones?
If I can just hold my hand up.
He's going to close it, and that will... Is that better? Is it better? Okay. I can also speak up. How's that?
That's perfect.
Okay.
Thank you.
You're here on a child support warrant from November of 2021. What we do in these cases is we give you a court date and a cash purge amount. So your court date is April 29th. That is this Tuesday, 5 days from now, 10 in the morning, in the downtown family court. The address is on your paperwork. And in this case, I'm affirming the cash purge set by the judge in 2021. It is $2,000. It is like a bond because you have to pay it or you don't get out. Unlike a bond, you never get it back. The court keeps it and they put it toward your child support debt. The cash purge is always far less than the total debt. So you still have to go on the 29th, even if you pay the cash purge. You must go or they'll issue another one for you.
Sure.
And so that's all we do in these cases. We don't appoint lawyers in these cases. You don't have any release conditions because it's not criminal.
Okay.
You just get a court date and a cash purge. If you pay it, show up. If you don't pay it, the sheriffs will give you a free ride to court. On the 29th, you can see the family court judge, do what you need to do, and the family court judge will decide whether you stay in for the cash purge or whether they let you out that day.
Okay.
Okay, there you go. You can go ahead and take your paperwork. Thank you.
Thank you.
Mr. Leija? Right here, sir. And then Markel Williams Bryant. Please go to the chair. Hello, sir. Can I have your full name and your date of birth, please?
James Sidney Leija, 9571.
All right, thank you. You're on a new case. And you got arrested for 2 allegations of identity theft. Those are class 4 felonies. 1 allegation of shoplifting as a class 6 felony. And there is probable cause for those. I am appointing a lawyer to represent you. Your next court date is going to be May 8th, which is 2 weeks from today at 8:30 in the morning, with a preliminary hearing May 12th at 8:30. And even though you have some criminal history, you qualify for release to pretrial services on this because it's a property crime.
Thank you.
Mr. Leija,
Yes, ma'am.
you can absolutely land yourself in prison in this case. So
I
you
know.
need to show up,
I will.
comply with your conditions. That includes do not go to this store.
I won't.
Absolutely no contact with any of the witnesses.
Nope.
You have to know if you miss a court date or pick up a charge,
Okay.
it's going to be a warrant issued for your arrest.
Okay.
You're going to get an envelope with instructions about how to call pretrial services after you get out. I want you to check in.
Thank you.
But Mr. Leija, it doesn't mean I don't think they have a good case. They appear to have a very good case against you.
I know.
I'm releasing you because I think you can be given a chance to prove whether you will or won't come to court.
Okay.
If you don't, this is what happens. You get a warrant and a bond.
Thank
so
you.
if you want to be out of custody while you defend your case, show up,
Yes, ma'am.
comply.
Yes,
All
ma'am.
right, good luck, sir.
Thank you.
Mr. Williams Bryant? And then I need to go. Is it okay? Did he fall? Okay. And then we're going to go back to the Youngtown guys. What did you find out?
Yes, Anna said they don't have court on May 1st, and they have to push it to the next Thursday, which is May 8th.
Okay. Lucky day, gentlemen from Youngtown. Alrighty. Sir, can I have your full name and date of birth?
Markel Williams Bryant, 0706-2005.
All right, thank you. You're on a new case. You're booked in on allegations of unlawful use of a means of transportation as a passenger. It's a Class 6 felony, and first-degree criminal trespass, a Class 1 misdemeanor. There is probable cause for both of those. Your next court date is a status conference, May 8th, which is 2 weeks from now, 8:30 in the morning in the Downtown Superior Court. Preliminary hearing, May 12th at 8:30 in the same court. Now, in your case, statistically speaking, which is because you're young and you don't have any convictions, you do qualify for release on your own recognizance. I'm going to go ahead and order that because what you're accused of isn't that serious. It's probation eligible, even if you lose at trial. I will say there are a lot of circumstances floating around the offenses that give the court great pause. And I saw the police allege that you had prior arrests or something in Illinois. We didn't find those. It doesn't mean a lot, but we didn't. I guess what I just want to say, Mr. Williams Bryant, is that number one, if you come in on a new felony while the case is pending, we're going to hold you no bond. It happened to somebody at the top of the calendar. I don't know if you were paying attention. You get held no bond automatically if you come in on a new felony while the case is pending. Number two, you could yet be charged with more things. Looking at this case, the police didn't think they necessarily have PC for you right now. I read probable cause statements all day, every day. We issue all of the felony warrants in this county of 5 million people. I read a ton of PC statements. You need to, I wouldn't play around with the county attorney's office and the prosecutions that go on in this county. That's all I'm saying. You're a young person. What you're accused of doing is basically edging over into behavior that looks to me like you're going to be back. I'm still releasing you. I don't like to see young people appearing to be going down that road and thinking that this is a slap on the wrist and you're walking out the door. When I read this, suspected armed robbery, somebody in the Wingstop with a gun stealing, people are going to prison all day, every day for this. And Arizona, please go out and Google the Maricopa County Attorney. They're taking a very hard line on this kind of stuff. She likes to announce in the press that we will not become the hellscape that is Los Angeles. So I don't know if you grew up in Arizona or not. Anyway, Mr. Williams, reading that and releasing you makes me feel like you're going to go like self-5 when you get out. Like, this is great. This is the offense conduct of somebody we're likely to see again. I really hope not. So, Mr. Williams, good luck to you. Don't have any contact with any alleged witnesses. That means don't go to that Wingstop. But the criminal trespass is for the yard. What's your question?
I don't live down here. I was supposed to leave today, actually. So what would happen with that? I want
you to prove that you'll come to court. So you're saying you're living in Chicago, or are you living in...
I live in Tennessee now.
Right. Prior arrest, ag assault on police in Chicago, aggravated unlawful use of a weapon in Chicago. I want you to prove that you'll come to court, Mr. Williams Bryant, and I will tell you, Arizona extradites. So you want to leave the state? I'm still going to release you on your own recognizance. Thank you for telling me that. That's a good sign. But if you're dumb enough to leave the court, leave the state, and just let a felony warrant sit in the system for you, that is potentially a life-changing decision. We get people picked up on warrants 10 years later, and they go, that was 10 years ago. And I said, well, they still want you. They say they want you, so we're holding you for extradition. So you stay, you come to court, you talk to your lawyer. Let me ask you this. What do you do in Tennessee?
I work, and I'm just down there with my dad.
Do you have a means to get back here by the 8th?
Yes.
All right. I'm going to let you go back and forth between the 8th. Here, now and the 8th. Do you fly?
Yeah, I can either fly or take the bus.
No, I don't care, but do you know what you're going to do?
Yeah, I'm going to fly.
Okay.
That'll be the fastest.
Do you fly direct, or do you go through somewhere?
No, I would be direct.
I'm going to put and airport states airports and You return by 5/8. You need to ask the judge, in your case, the trial judge, you need to ask for ongoing permission to travel. I can only give it to you between now and then. So figure out a way to get here. We're going to give you a piece of paper for the public defender, call them, if you want to try to get a continuance. If you want to say, like, May 8th, could we push it a week or two? Call your lawyer. Your lawyer needs to file for continuance. If you're not there, they're going to issue a warrant for your arrest. All right, Mr. Williams, we're going to get that printed up for you. You will be released later today. Don't miss your court dates. Don't violate your release conditions. Did I put no defendant? Yeah, I put no contact with any co-defendants. That's not going to end well. There's a short-barreled rifle. There's an alleged armed robbery. These are just booking charges. It's up to the county attorney, and the county attorney may do what they call furthering it, which means they don't file it yet. They ask for further investigation, and then they file it on you later. So you need to make sure that you have a good mailing address on file with the court if that happens to you, because they're going to send you a summons. And if you don't get it, you could end up extradited from another state 3 years from now, and you'll go, oh, I never heard from them again. I thought nothing ever happened. There's a 7-year statute of limitations on felonies. The county can charge you a year from now. So you need to make sure that you have a valid address on file so that you get the summons when it comes.
Yeah, my address will be updated on the 30th.
Good. All right. Everything's on your paperwork. Don't violate that. Good luck, sir. Mr. Garcia, Anthony, or let's do actually, Mr. Garcia, sit down. I want to do the Youngtown guys first. Let's get them out of here. That was Villalba and Phyllis. Okay. Sure, Villalba, please. Yes. Okay. So hold on 1 second. 1 second, Mr. Villalba. Alrighty, we're going to go back on the record in Rocky Villalba's case. I talked to him. It's ready to play. I don't know, 15, 20 minutes ago. Mr. Villalba, my staff did check. Apparently, Youngtown they are indeed closed on May 1st. And so they've pushed everything to May 8th, which is not within 10 days, which means only in the Youngtown case, I must release you. So that's going to change your court. It's actually going to leave your court date May 8th, which is 9 in the morning. So if you're still in custody in your probation case on May 8th, you're going to catch a warrant, maybe try to call Youngtown in advance. But your court date in your probation case is May 1st. So you could... Exactly, you might be, indeed. Many people are. Like, if you get reinstated, you might be done that day. They may give you a jail term. I don't know. That's up to the probation judge. But just don't forget, you do have a court date in Youngtown on the 8th. You're not in custody on that case, though. So your only bond is the $250 for the probation case, all right? We're going to get that printed up. You can take that with you as you go. All right, thank you. Mr. Phillips? All right. I didn't even get your name, I think.
Tyler? Yes, ma'am.
Go ahead.
My name's Tyler Phyllis.
June 1490?
June 1490.
Okay, thanks. So you're here on a Youngtown City Court warrant. It is for failing to appear in a case that you've been charged with criminal damage, drawing on property. So I guess that's some kind of graffiti charge. I get abbreviation. The alleged offense date is August 7, 2024. This warrant issued March 24th of 2025. So I'm not appointing a lawyer for you because I'm not holding you on a bond.
Thank you.
Your arraignment hearing, May 8th at 9 in the morning. You are released because I cannot give you a court date within 10 days as is required by law.
Thank you, ma'am.
You do have written release conditions. Don't go to the scene of the alleged crimes. No contact with any alleged victims. No weapons, no drugs, no alcohol. You need to go to court. Judge Anderson wanted a $1,200 bond for you. I don't plan to set that, but I know Judge Anderson. I don't know if you know Judge Anderson.
I don't know.
You should show up.
I might. I will. I definitely will be.
He is the kind of misdemeanor judge who gives jail time.
Yeah, I definitely will. I
go.
I got out of rehab, to be honest, and I just spaced it. But now that this new date is here, I promise I will make sure I'm there.
In terms of soft-hearted judges, Judge Anderson doesn't immediately come to mind. Let's put it that way.
Yeah.
So.
He's a good man, though.
You should please him by appearing on the 8th. I'm also ordering you to and saying it happens again. You're definitely getting a bond. You just got lucky.
Yes, ma'am.
So, all right. If you step to your left, you get paperwork.
Thank you.
All right. So what I want to do, officers, I want to do my house calls because the last two, well, there's the Spanish guy who I want to do in like 7 minutes. So see if we can fast. Oh, no, I forgot. Shoot, I've got FOJ guy. All right. Go ahead and come in, sir. I am going to take a break in like 7 minutes and do I want to do the Spanish matter, officer. You know we got to clear, right? Okay, thanks. But I don't, my interpreter's doing us a huge favor by doing it at lunchtime. So I said I'd stop at 12:15 no matter what. Thank you so much. So I may be like, pause in the middle of yours. Okay. Give me your full name and date of birth.
Anthony Joseph Garcia, November 30th, 2003.
All right, thanks. You're here on two things. One is a new case here in Maricopa County. One is your warrant from California. We'll start with your Maricopa case. You got booked in for aggravated assault by the impeding of breathing or strangulation in a domestic relationship. That is a Class 4 felony. There is probable cause for it, and I am appointing a lawyer for you. Your next court date is a status conference, April 30th at 8:30 in the morning, with a preliminary hearing May 2nd at 8:30, same court. And as you are no doubt about to learn through your lawyer and the way that the county attorney views these, there is substantial research that shows that strangulation in a domestic relationship is a massive red flag for future murder. It means, statistically speaking, the alleged victim in this case is 7 times more likely to be murdered by you at some point. Also, the court notes she was 7 months pregnant, which strongly indicates the possibility that you are dangerous to her and to the unborn child. So, on that basis, in addition to any bond that may get set in the California case, bond is set in your case at $25,000. It is cash only because the court also believes you're a flight risk in this case. So you'd go on an ankle monitor in the Maricopa case if you did post a bond. Absolutely no contact with her for any reason, whether you're in or out of custody. Can't live where she lives. You can do a civil standby to collect belongings. No weapons, no drugs, no alcohol. Obey any order of protection you've been served with. That's the Maricopa case. Now, the California case is very different because it's an out-of-state warrant. And in the California case, you have extradition rights. And there are 4 basic rights. The first one is to have an extradition hearing here in Arizona within 90 days after today. As part of that process, you get your second right, which is the right to insist that a governor's warrant be executed by the sitting governors of each state. That means Gavin Newsom and Katie Hobbs have to manually sign a governor's warrant. And that has to be presented in Arizona before California can take you back there without your agreement. If you don't agree, they must present a governor's warrant in order to be legally allowed to take you from here to California. That's your second right. Third right is to hire a lawyer at your own expense in the extradition case, because extradition proceedings are civil proceedings. They are not criminal proceedings. And so we don't appoint a lawyer for you as a matter of right. What you have is the right to hire a lawyer at your own expense. Fourth right is the right to bail if you don't agree to go back. If you don't agree to go back, I'm going to set bail in the amount requested by California, which is $55,000. That would be cash only. On top of the $25,000 in Maricopa, that's $80,000 cash, plus ankle monitoring in the Maricopa case only if you make bond. So that's if you don't agree to go back. Then your extradition case is going to go forward because you didn't agree to go back. They need to give you that hearing within 90 days. You're going to have at least 2 hearings between now and your actual extradition hearing. So we have an extradition judge, and I would give you your first court date in front of her on May 5th at 1:30 if you don't waive. Waiving means you bypass the entire extradition process and you just agree to go back. You consent to go back.
That's what I was
Then you have to give up all 4 of those rights. You will not have an extradition hearing within 90 days. You will not get the governor's warrants issued and signed. They don't have to do that because you agreed to go back. Although you can always hire a lawyer to represent you, there won't be a court case. The court case will end today if you waive today. So you could hire a lawyer, won't do any good. And I must hold you without bail if you waive. You will not get bond. And that is because if you waive, California is going to get 30 calendar days starting at the conclusion of any local cases to come and get you. But you do get held no bond from the moment that you waive. And we know you have at least 1 open Arizona case because I just told you what it was. So if you were to waive today in the California case, you would go no bond in California. I'd still give you the $25,000 in the Arizona case. You would progress through your Arizona case. Once that was done, plus any others, I don't know what else might be out there. Okay, this is the only one. It's either dismissed, you get convicted, or you get acquitted. That's how you're done. Once that's done, California will be notified. They'll have 30 calendar days to come and get you.
Yeah.
If they don't, you get released. But the California warrant stays active in the national system, and you could literally be re-arrested on the same warrant the next day, because our court cannot quash a California warrant. You have to do something about it in California. If they don't come get you, you need to start talking to that court. You need to try to show up. You need to do something to clear that warrant, to get California to clear that warrant, because we can't. So I was warning people about that. Now, if you don't waive today, you'll be back in court on the 5th of May. If you wanted to waive then, the extradition judge, she takes waivers at the start of every one of those weekly hearings. If you wanted to do it, you can. You never have to. What else was I going to say? Oh, there is a public defender there. She is not your public defender unless the probation judge decides to appoint her. She can do that within her discretion, but you just don't have the right to it. So just so you know, if you wanted to get some legal advice, we do generally have a public defender assigned to extradition court. She's very experienced, but that's because we have the resources and it helps everything move more efficiently. Okay, so any questions? I know that was a lot of info.
Yeah, I do have. So my main two questions would be, for one, so if I were to like waive it and I were to decide to go through, like, because I don't have a problem going to California and like turn myself in, like do that. But how, you said I would need 25,000. I mean, 2,500 or 25,000?
1,000.
And that's in full?
Correct.
Okay, and so there's like basically no chance of me getting released until it's all figured out, huh?
Now, unless you have somebody, you have the money to put up, or somebody likes you enough to put up the money for you.
$25,000?
Correct. Even if you did, though, you get held no bond. If you waive in the California case, you're not allowed to bond out. If you agree to go back to California, you turn into no bond immediately, the whole time.
Okay.
We don't let people run around after they've agreed to go back.
Okay.
Some people play the float in your situation. They don't waive at this hearing because they've got another pending felony case.
Yeah.
And so if you want to keep your rights for now, you can go talk to your lawyer next week on the 1st, well, it's the 30th. In the strangulation case, that's the 30th. They can't represent you in the extradition case, but they might have input or guidance or suggestions.
Yeah.
On the 5th of May is when you would go to extradition court. And like I said, there's a general public defender assigned there. I'm not appointing a public defender for you. The extradition judge can, if she wants to, appoint the PD in your case, but that's entirely up to her. She's got her own, decision tree for that.
Yeah.
But in any event, so some people in your situation play the float and they don't start the extradition clock yet. They don't waive their rights. They keep their rights so that it lets you, I guess, maximize your decisions later.
Yeah.
Some people want to waive. I can take a waiver if you want to waive, or if you want to just keep your rights and go back to extradition court, that's fine.
I think so, because I'm still kind of like a little bit confused, but I think I'm getting it. So I don't have to do this today, and I'll still be good, and then I'll have a chance to talk to a public defender?
Yep, you can waive at any time. The probation judge will take your waiver on the morning of your extradition hearing if you want to waive.
Okay.
So don't worry. So that way you could waive on the 5th if you talk to the PD there and you decide that's the best decision for you. You never have to waive. You have the right to these things. You do not have to give up your rights.
Yeah.
Okay. All right, so I'm going to note that you keep your rights. I've told you your next court dates. We're going to get that printed up and sent out to you. I do have my interpreter here. It times out nicely. So they're going to probably take you all the way out, if you would, officer, and then we'll send out the paperwork as soon as it's ready.
Okay, what do I do with this?
Oh, just leave it right there. It's fine. Yeah, thank you very much. Okay, thank you. And I should be down to... Who do I have? I see the Spanish guy. It should be him and Kevin Rhymes. There should only be two people. It should be Kevin Rhymes and Fabiola Farfan. Okay. Let's get the Spanish speaker in here, please. All right. And, okay, thank you. All righty. And can the interpreter hear me?
Yes, sir. Martin Hernandez, court interpreter.
All right. And thank you so much for this. We super appreciate it. All righty. Sir, please wait for the interpreter and tell me your full name and date of birth.
Señor, por favor, espere al intérprete y dígame su nombre completo y fecha de nacimiento.
Faustino Vicente Favila Farfán, 17 de abril de 1968.
Faustino Vicente Favila Farfán, April 17th, 1968.
All right, thank you. You are before the court for two matters.
Muy bien, gracias. Usted comparece el día de hoy por dos casos.
One is a new felony arrest, and the other is a traffic court warrant.
Uno de los casos es un caso nuevo por comisión de un delito. El otro es por una orden de aprehensión por una infracción de tránsito.
I will start with the felony case in which you have been accused of the following offenses.
Vamos a empezar con el caso por delito en el que se le ha imputado algunos ilícitos.
2 allegations of sexual conduct with a minor, which are Class 2 felonies.
Tiene 2 acusaciones de conducta sexual con un menor, delitos de categoría 2.
4 allegations of sexual abuse of a minor, which are Class 3 felonies.
Tiene 4 acusaciones de abuso sexual de menores, son delitos de categoría 3.
Based on what the police have submitted, there is probable cause for all of those crimes.
Basándome en lo que la policía ha presentado, dicto que hay motivos de procesamiento por esas acusaciones.
I am appointing a lawyer to represent you in this case.
Le asignaré un abogado para que lo represente en este caso.
Your next court date is a status conference, April 30th at 8:30 in the morning.
Su siguiente comparecencia es una consulta de actualización el día 30 de abril a las 8:30 de la mañana.
And your preliminary hearing is scheduled for May 2nd at 8:30 in the morning.
La audiencia preliminar está programada el día 2 de mayo a las 8:30 de la mañana.
The court address will be on your paperwork.
La dirección del tribunal a donde se presentará figurará en la hoja que se le entregue.
Okay.
And in the traffic case, you have been convicted of leaving the scene of an accident, a Class 2 misdemeanor.
En el caso de tránsito, se le acusa, usted ha sido juzgado culpable de un cargo de abandonar la escena de un accidente, una falta de categoría 2.
And on January 26th of 2023, the Justice Court issued a warrant for your arrest for failure to pay your fines and fees.
Y el día 26 de enero del 2023, el Juzgado de Paz libró una orden de aprehensión por usted por no pagar las multas y aranceles correspondientes.
You will have an arraignment hearing in the Hasayampa Justice Court on May 2nd at 8:30 in the morning.
Usted tendrá una vista incoatoria ante el Juzgado de Paz Hasayampa el día 2 de mayo a las 8:30 de la mañana.
I will give you a chance to speak in a moment.
Le daré momento para hablar enseguida.
All right. In the new felony case, for the reasons set forth in my written order, your release conditions are as follows.
En el caso nuevo que tiene por delitos, I'm sorry, Your Honor. En el nuevo caso que tiene por delitos, las razones por las siguientes condiciones de detención o libertad figurarán en sus documentos por escrito, y estas son.
And let me pause to say that one of them is that based on the allegations in your case, you face the possibility of a very long mandatory prison sentence.
Y déjeme pausar un momento para decirle, basándome en las acusaciones que se hacen en uno de los delitos que se le imputan, usted encara la posibilidad de una pena penitenciaria muy larga.
And so in addition to the danger that the court believes you may pose to children in the community and specifically to this alleged victim, the court believes you may flee the jurisdiction to avoid prosecution.
Aparte del peligro que yo pienso que usted representa a los niños en la comunidad y en especial a esta víctima en particular, esta sala piensa que usted es una persona propensa a la fuga.
For those reasons, bond is set in your case in the amount of $250,000 and it is cash only.
Por esa razón, la fianza en su caso se fijará por el importe de $250,000 en efectivo.
If you post that, then you must by law be on an electronic ankle monitor.
Si usted presta esa fianza, la ley requiere que usted esté en libertad provisional con un grillete de monitoreo.
Whether you are in or out of custody, you may not have any contact with anyone under the age of 18.
Así esté usted en libertad provisional o preso, usted tendrá prohibido tener contacto con personas menores de 18 años.
That includes any minor children that you may currently have.
Esto incluye niños suyos que sean menores de edad.
Absolutely no contact with the alleged victim for any reason.
Se prohíbe en lo absoluto contacto de cualquier tipo con la víctima.
You may not possess any weapons nor any drugs without a valid prescription.
Tiene prohibido tener armas. Tiene prohibido tener drogas sin una receta médica.
The remainder of your orders will be provided to you in writing.
El resto de las condiciones de su libertad se le entregarán por escrito.
In the traffic case, your bond is $250 secured.
En el caso que tiene de tránsito, la fianza es de $250, fianza respaldada.
And you have written conditions in that case also.
Hay condiciones de libertad por escrito para ese caso también.
So was there anything that you still wanted to say?
¿Hay alguna cosa que usted aún quiera decir?
Sí, nomás, si pago los 200,000, ¿me lo deja pagar poco a poco o todo junto?
Yes, regarding the $250,000, if I pay that, am I allowed to pay it in payments or all at once?
All at once.
Todo junto.
Oh, si me lo puede dejar que los consiga.
Oh, may I have time to get that together?
You may, but you stay in custody unless it's paid in full.
Usted puede tener tiempo, pero permanecerá preso hasta que la pueda pagar por completo.
Pues que no tengo ese dinero ahorita y tengo que trabajar para juntarlo. Alguien me va a prestar algo, pero puedo conseguir otro poco más.
Thing is,
Porque aquí cerrado no tengo nadie, tengo que salir a hablar con él para que me presten el dinero.
thing is, I don't have that amount of money right now. I mean, I need to work in order to get it together. I will, of course, I'm going to borrow some from some people who will lend to me, but I need to be out in order to speak to them to get them to lend it to me.
Right. The court is not going to permit that in a case like this.
Este tribunal no permitirá eso en un caso como este.
The state appears to have a strong case against you.
El Estado parece tener un caso muy bien fundado en su contra.
And the court will not take the risk that you will flee to avoid a 20-year prison sentence on anything less than this amount.
Y este tribunal no se arriesgará a que usted se dé a la fuga para evitar la condena larga. No será algo menos de esta cantidad.
We're going to get you your paperwork if you
Tengo mucho tiempo aquí, no me he ido, pues he trabajado para pagar todo lo que debo. Del otro estuve pagando, pero ya me quedé sin trabajo, pues no lo acabé de pagar.
Well, I've been here for a long time, and I work to pay all the things that I owe. Regarding the traffic ticket, well, I stopped. I was paying, but I stopped because I lost my job.
All right, sir, the court is not at all concerned about the traffic ticket. I'm concerned that you committed sex crimes against a young child and you're facing decades in prison.
Señor, a esta sala no le interesa para nada la cuestión de tránsito. Lo que me preocupa es que usted cometió ilícitos sexuales en contra de un menor y está encarando décadas en la cárcel.
So talk to your lawyer about any motion to modify your release conditions.
Así que hable con su abogado con respecto a la petición que quiera hacer para hacer cambios a sus condiciones de detención.
And they'll have your paperwork for you if you step that way. Okay.
Le darán una hoja si pasa allá a la izquierda. Gracias.
Gracias.
Thank you.
Okay, and thank you so much to the interpreter. I, again, super appreciate it. Thank you.
You're welcome, Commissioner. Bye-bye.
Have a good day. It fools me because it looks like I signed it. Okay, those are good. All right. Okay, so I think, I don't know, when we have rhymes, I'll do rhymes, but I can do the house calls now while we wait for rhymes. I haven't done the house call record. So at your leisure, we just need to get his stuff printed. Where's rhymes back there?
So they're
Okay, thank you. All right, so.
Your Honor, Mr. Garcia was done, correct?
He is done, yes. I didn't click the right signing button. All right, so Aiden Laskowski, Sonia Overleen, Chelsea Gilbert, and Raquan McClurkin. Officer, are they not physically present in court because they've been isolated by the sheriff's office as potential risks to themselves or others?
That is correct.
All right, I did get an affirmative answer from the sheriff's office. So I will conduct each of those initial appearances in-house, in person, immediately following this recording. And in one moment, I'm going to have, I think we can go ahead and come in. Are you Mr. Rhymes? Go ahead and come in, Mr. Rhymes. All right, sir, can I have your full name and your date of birth, please?
Kevin Lavelle Rhymes, 10-8-79.
Okay, thanks. You're here on a grand jury warrant because you've been indicted in a new case. The first count is child abuse as a Class 3 felony, and that's why we waited to do your hearing when the courtroom cleared, because sometimes that charge can make you a target of other inmates, so it's just for your safety. Then tampering with physical evidence, a Class 6 felony, and misconduct involving weapons, a Class 4 felony. The alleged offense date for all of these is March 20th of 2024, and this looks like it comes out of the Glendale Police Department. You will get copies of police reports and the charges from your lawyer. I am appointing a lawyer for you. Your next court date is an arraignment hearing on this warrant, which is May 1st, 2025, which is a week from today, 8:30 in the morning in the downtown Superior Court. I am affirming the bond ordered by the grand jury judge, which is $10,000 secured. If you post it, be sure to comply with your release conditions, and whether you're in or out of custody, you can't have any contact with the alleged victim. Sometimes in cases like this, you may literally have been living with the alleged victim yesterday. I don't know. But if you have been having contact with him, that stops today.
It's my son.
So you're under the court order now. So whatever has been going on since May of 2024, if you've been, like I said, if you literally had contact with the alleged victim yesterday, that's okay. Now you're under a court order, so it stops.
I have a DCS case and I have sole custody, and
DCS is going to have to remove then. I just ordered you to have no contact.
They've already been removed, but this is what I don't understand is, so the charges keep changing.
Okay, that's sorry. I don't know how that's relevant today, and nor could I possibly explain it to you because I don't know the progress of your case. So you got indicted. That means the grand jury met, they heard evidence, and found probable cause to charge you with these felonies. So I don't know what went on before. I don't see any other cases since 1997, not criminal cases. I only see this one for Maricopa County. So I don't know what's been going on. What I know is the grand jury judge heard what was alleged against you, and settled on the $10,000 bail. So in a case like this court is not going to give you permission to have contact with this alleged victim. You said you have sole custody, but DCS removed.
Yes, but...
Okay, so are you in dependency proceedings?
Yes.
Okay, this supersedes anything that's going on in that, meaning this is a felony criminal case. It can be a felony to violate this order, so don't do it. Talk to your lawyer. Don't just decide you don't like it and violate it. You're facing potential prison in this case. Don't mess with these release orders. So that's why I just try to point out to people, you're not the first person I've seen in this situation, that this victim may literally have been living with you yesterday when you got arrested. That was okay. Now you're under a court order in a felony case. It's no longer okay. And so however it goes down, it sounds like, you know, they're not physically living with you anyway right now. And so it's easy to comply. If you were having some supervised contact or something, you can't until you get an order from the criminal judge. So talk to your lawyer. Okay. Like I said, I don't know the facts of your case. Victims' rights need to be complied with. Basically, a careful order needs to be crafted if the trial judge is going to do it. This is a very limited type of proceeding. I don't have nearly enough facts to make a good order, so I'm erring on the side of that child's safety. And that is very clear cut to this court in a case like this. You cannot come in on a child abuse charge and walk out the door with permission to have contact with that kid. You need to go to your trial judge. They are very unlikely to do it. It's within their power. Talk to your lawyer. If something can be arranged that the judge is willing to sign off on, that could happen. But between now and then, don't violate this court order.
Well, my other question would be, like, the charge makes no sense because I was outside working on my car.
Sir, I don't decide. The grand jury heard evidence and found they gave you a formal probable cause finding, which is better than what I normally get and am able to do. This is not a formal probable cause finding, but you got one. You got a grand jury. So as far as whether these are good charges or bad charges, I literally don't know because the grand jury transcript is going to be unsealed between today and your arraignment. The grand jury proceedings become unsealed now that you've had this hearing. I don't know what's in them, nor do you. Okay. So talk to your lawyer about all of this. I'm just trying to stress, don't have any contact with this alleged victim until you get a court order from the trial judge that changes mine, because mine says 0, none, nada.
When am I going to trial?
Oh, you don't have a trial date yet. You just have an arraignment. To go to your arraignment hearing, they're going to give you some future court dates. And the arraignment hearing is just a little bit procedural and not all that meaningful, but it's a formal reading of the charges. You square up with the lawyer a little bit and you get court dates. It's pretty simple. So I don't know that they'll even set a trial date then. They're just going to set your trial management conference. They set about 3 hearings then. So go find out next week. You'll get a better idea. You have speedy trial rights, which is only slightly embarrassing. I think it's 6 months. Okay. So talk to your lawyer about that. That's literally why you have a lawyer. I did appoint the public defender for you. Okay. All right. If you step to that, it gets picked up. All right. Thank you. All right. So I talked about my house call reasons a couple minutes ago, and so I'm just going to make my little brief recitations here. I will let Aiden Michael Skowski, born 12803, know that he's here on a new case. He got booked in for third-degree burglary, class 4 felony, and theft of class 6 felony. And there's probable cause for both of those. I'm appointing a lawyer for him, giving him a status conference court date April 30 at 8:30 in the morning with the preliminary hearing May 2nd at 8:30, downtown Superior Court. And based on what was submitted, I am inclined to set bail in the amount of $5,000 secured with written conditions that I will go over with him, including no going to the scene of the alleged crimes, no contact with any alleged victims or witnesses, no weapons, drugs, or alcohol. Sonia Overly, born 12/28/91, here in a new case. She got booked in for third-degree burglary, class 4 felony. There's probable cause for it, and I am appointing a lawyer for her. Her status conference will be April 30th at 8:30 with a preliminary hearing May 2nd at 8:30, both in the downtown Superior Court. And in this case, I am inclined to set bail in the amount of $2,500 secured with written conditions that include no going to the scene of the alleged crime and no contact with any alleged victim. Ms. Chelsea Gilbert, born 7/16/88, is here on a bench warrant for failing to appear in a case in which she's been charged with 2 counts of aggravated assault on a first responder, those class 4 felonies, resisting arrest, class 6 felony, and disorderly conduct, a class 1 misdemeanor. She already has a lawyer appointed. Her status conference will be April 30th at 8:30 for preliminary hearing May 2nd at 8:30 in the downtown Superior Court. and I'm inclined to affirm the bond set when this warrant was issued. She did come up with a maximum risk assessment score, and that bond amount is $500 secured with written conditions that I will go over with her. McClurkin, born 8/22/96, is here on two matters. One's a new case. One is a probation warrant. In the new case, he was arrested for robbery, a Class 4 felony, and dangerous drug possession, a Class 4 felony. And I thought I recalled that I did not. Okay. I want to reprint number 40, please, which is the 2017 for Mr. McClurkin, because I meant to find no PC for the dangerous drugs, and somehow I did not correctly check that box. Double check. Yeah. Double check that. I don't know why that popped into my head, but yeah. All right, no PC for the drugs, but yes, PC for the robbery. I will explain that to him, and I'm giving him a word. Status conference in this new case, April 30 at 8:30, preliminary hearing May 2nd at 8:30, both in the downtown Superior Court. Currently inclined to set bail in the amount of $10,000 secured with written conditions I'll go over with him, which include no going to the scene of the alleged crime, no contact with the alleged victim. All right, finally, he's here on a probation violation where he's on probation for a Class 2 felony. Sorry, this is though term 1 hold. And the probation department will be filing a petition to revoke his probation based on the new arrest. And so I'm appointing a lawyer for him, giving him a revocation, arraignment, and possible disposition hearing date of May 1st at 8:30 in the morning. And I'm currently inclined to hold him without bail because I do find that in all reasonable probability he's going to be revoked to prison in his probation case. So he does not have bail today, and I will explain that to him. If anything changes after I conduct these initial appearances in-house, my final written order will reflect the court's ultimate decision. In that case, it is not this court's intention to update this recording. The final order issued by the court will reflect the court's ultimate ruling once the initial appearances are conducted. And with that, this court is going to stand in recess until 2 p.m. this afternoon.